Good morning. Welcome to day 2 of the AALS conference on rebuilding democracy and the rule of law, co-hosted by the ABA and the LSAC. For those of you who were able to join us yesterday, I hope you found the panels as rewarding as I did. The conversations about the presidency offered a wide array of perspectives and insights on this critical power in American democracy. It was particularly enlightening to have Bob Bauer and Jack Goldsmith discuss their book with us in person. And once again, I want to offer our appreciation for their work and our thanks to them for joining us. Today, we move to the topic of the franchise, that most critical tool for meaningful citizen participation in the democratic process. Our panels today will cover 3 topics: congressional legislation to protect voting rights, race and voting rights, and improving presidential elections. It's particularly fitting that we move to this topic the day after Governor Ron DeSantis of Florida signed a sweeping new piece of legislation that proponents claim will protect the integrity of elections, but which most objective observers have described as legislation that restricts voting access in ways that will disproportionately affect people of color, rural voters, and blue-collar voters. This comes on the heels of similar legislation passed in Georgia, and yesterday, legislation that passed the Texas House of Representatives that will no doubt soon become law. The legislation in Florida felt particularly personal to me. In the early 1960s, my father was a voting rights activist in South Florida, working to help Black people gain access to the franchise in a state that was, at that time, still very much a part of the Jim Crow South. 60 years later, much has changed in Florida, but these new attempts to make voting more difficult, wrapped in the rhetoric of election integrity, is uncomfortably familiar to my dad and to those who worked alongside him, often at great personal risks to themselves, to allow all Americans full access to their rights as citizens. It is then very fitting that today's proceedings are opened by a public servant who has become a champion of voting rights and election reform in our current era. On a personal note, it's rewarding to look back on your classmates from college, or in this case, law school, and think about those among them who have gone on to do great things in the service of others. John Sarbanes was one of those people. Someone who, even when we were in law school, had a passion for public service, social justice, and politics. Our paths have not crossed in a very long time, but I'm thrilled to reconnect with him today and to welcome him this morning to open day 2 of our conference. Congressman John Sarbanes led the US House of Representatives in passing H.R. 1, the For the People Act, a historic suite of reforms to protect and expand the right to vote, clean up corruption in Washington, and restore trust, transparency, and integrity in government. In March, when the legislation passed the House, Representative Sarbanes stated that the legislation, quote, sends a strong signal to the American people about our unwavering and longstanding commitment to enact transformational, anti-corruption, and clean election reforms. Congressman John Sarbanes has served as the representative of Maryland's 3rd Congressional District in the United States Congress since 2007. He currently serves on the House Committee on Energy and Commerce and the House Subcommittee on Environment and Climate Change. He serves as vice chair of the House Subcommittee on Health. Congressman Sarbanes also serves on the House Oversight and Reform Committee and its Subcommittee on Government Operations. He chairs the Democracy Reform Task Force, which has assembled H.R. 1, the For the People Act, to reform and strengthen our democracy. Born and raised in Baltimore, Congressman Sarbanes has experience working in the public, private, and nonprofit sectors. He and his family live in Towson, giving him the opportunity to drive home every night and hear from the people he serves in Congress. Listening to their concerns allows him to better represent Maryland and has shaped his work in the House of Representatives. So now let me turn the microphone over to our honored guest this morning, Representative John Sarbanes. John.
Thank you very much, Vince. It's great to be with everybody today. And yes, it has been a while since you and I have connected, so this is a great opportunity for that. Thank you for your good work. Thank you for this conference, and to all the participants and viewers and listeners for their interest in this very, very important topic of democracy reform. At what is a hugely consequential moment of opportunity, I think, for our democracy in terms of resetting the basic rules, shoring up the foundation of it. And this has been a focus of mine for some time. So it's nice to see that we've got something assembled in terms of reform that we think can meet the moment. I wanted to talk a little bit about that. You've got a terrific panel following me, including Guy Uriel Charles, who recently testified in front of the House Administration Committee on H.R. 1. We certainly appreciated that, and other very distinguished panelists on this topic. So I'm humbled by that, but I'll do my best to lay out a perspective here on kind of how we got to this moment of opportunity, and frankly, in some ways, crisis for the democracy. I've been paying attention to this really since I came to Congress 15 years ago, but most intensely over the last 4 or 5 years. The reality is that many Americans, arguably most Americans, have gotten increasingly disconnected from their democracy and their sense of place within it over the last 10, 15 years. And I think all of that's come to a head in the very recent past. To put it simply, they look at Washington in particular, and they increasingly have felt that Washington lawmakers are listening to a small, sort of privileged group of power brokers and not really translating the will of the broad public anymore. And that has led to deep cynicism out in the country. That cynicism has found its way to some expressions that I think have kind of rocked our democracy over the last few years, and have put a fine point on the need to provide fundamental reform, a total reset of the democracy. So we've had that angry and cynical feeling out in the public. I think in 2016, to be very honest, candidate Trump found that anger, and he sort of translated it into the slogan of coming to Washington, draining the swamp, and so forth, and channeled that in a way that he was able to take advantage of electorally. When he got to Washington, in my own estimation, he didn't do a whole lot to address that issue of draining the swamp and cleaning up our politics, but he certainly understood that the sentiment was broad and deep out in the country. And I think kind of grabbed that, took it in a destructive direction, but lifted up that it was a problem, that there was this feeling out there that needed to be addressed. The good news was that in 2018, we had a set of reform candidates that ran across the country, many of them in districts where the president had done well in 2016. They found their way to that same sentiment, that same sort of cynicism and frustration in the body politic, but they offered a different solution, one that I would argue is more restorative. And that was to say, we know you're angry at the state of our politics and our democracy. We're going to offer you the solution of going to Washington and trying to fix what's broken and rebuild things so that you're at the center of your democracy, you feel included again. And that message was very well received. It's what allowed us to bring a reform agenda into the House of Representatives in January of 2019. And we had by that time constructed a blueprint, which ultimately became H.R. 1 for the People Act, which is now S1 on the Senate side, I'm glad to see, which kind of demonstrates the priority position that this legislation has right now. But we had constructed by 2019 a broad framework bill of comprehensive democracy reform. And in that sense, we're ready to channel that frustration, anger out there in the public in a very productive and restorative direction, as I say. Let me pause and talk about what's in the bill, because it represents, in my view, a direct response to the grievances that we've heard from so many Americans for so many years. Oftentimes people look at the bill and they say, well, that's a lot to bite off. It's too big, it's too expansive. But I can tell you that in many respects, it's very lean in its response to what the public wants to see. In other words, it's meeting all of these different demands and putting them into a single interlocking package. So it breaks into about 3 or 4 or 5 key components. The first, as was mentioned, and is the central theme of much of the discussion you're having, is the right to vote and access to the ballot box. We've been hearing for years from members of the public that there's deep frustration at this crazy reality that every 2 years you have to run an obstacle course to get to the ballot box in America. We should really be the gold standard when you look around the world in terms of access to the franchise, and yet we lag far behind our peer nations. In fact, I think Freedom House recently did their democracy score, and the United States had fallen 11 points from, I think, 95 to 84, based on some of these fundamental frustrations, like not being able to vote in a convenient and simple way in this country. So many of the reforms that are included in HR 1, the For the People Act, are designed to do just that, broaden access to the ballot box. In a sense, make it so that when you get up on the morning of the day you've decided to cast your vote, whether it's filling out an oval on a mail-in ballot or going to an early voting site, or showing up on election day to cast your vote, you have confidence that you can complete that transaction without having 4 or 5 contingency plans available to you. So this is a critical component. Title I of the bill was largely written by John Lewis, who for 5 Congresses in a row had introduced something called the Voter Empowerment Act, which is broad legislation to increase opportunities for voter registration, automatic same-day online voter registration, to expand absentee ballot voting across the country on a no-excuse basis, to establish baselines for early voting, and to push back with severe penalties on voter suppression and voter intimidation and other mischief that we've seen used to block people's access to the ballot box. So that's a fundamental component of the bill. But that's not all the public was saying to us. Yes, they want to make sure that access to voting is there, the freedom to vote is intact, but they also understand, and if you listen carefully, as I try to do with my constituents, that being able to cast your vote freely and elect people to go to Washington is only a partial answer in terms of your voice in your democracy. You have to make sure that the people that you send, when they get to the places where laws are made, in this case to Congress, to Washington, or in a sense serving in the executive branch, that they continue to carry your voice with them, and that they not be compromised by ethical conflicts, that they not be captured by big money and special interests that operate very fluidly on Capitol Hill. And so other reforms were also ones that people were clamoring for, and that we tried and have built in to the basic architecture of the For the People Act. This includes ethics reforms in terms of lobbying reforms, more transparency and accountability, conflict of interest rules, a code of ethics that applies to the executive branch, reforms for how lawmakers in Congress behave, a code of ethics for the judicial branch, other things just to restore and establish in a robust way a culture of ethics in Washington. A third thing that we heard from people is high anxiety about vulnerabilities in our election infrastructure to disruption and interference from foreign actors. So we've built a whole section of the bill that addresses that component. Partisan gerrymandering has been a complaint of the public's. In a way that can be used as a form of voter suppression. So it ties directly back to the overall goal of trying to promote fair representation out there. And we have a fix for partisan gerrymandering included within the bill, because again, another key source of frustration in the public. And then the last broad area of reform, which is really fundamental, is this idea of how do you make sure that the will of the people doesn't get frustrated, compromised, or undermined by the inside influence that special interests, and particularly big money interests, can have on the way the system operates. So we have robust reforms within the bill, things like fixing the Federal Elections Commission, which doesn't operate now, it's dysfunctional, promoting disclosure and transparency of the secret dark money that's been coming into our democracy for years now, and really at a exponential level since the Citizens United case was decided back in 2010. And then finally standing up a system of funding campaigns that's based on small donors and matching funds, which is proven at the state and local level to be very empowering for everyday Americans, but also helping to promote diversity in the candidate pool, because it allows people who traditionally could not access the dollars you need to run a viable competitive campaign for Congress to be able to power their campaigns by collecting small donations and earning matching funds. And there's studies that show that this would substantially increase race and gender and socioeconomic diversity in Congress if you could get this kind of a system in place. So all of these different reforms have led to the fact that the bill is expansive. It's over 800 pages, but they're all designed to respond to the basic set of concerns that we were hearing from Americans for years. And this helps explain why when you look at the polling data, a majority of Americans of all political stripes, Democrats, Independents, and Republicans, support this kind of reform package, and it earns very high marks. Now, unfortunately, the leadership on the Republican side of the aisle in Washington has made a decision. They made it in the 116th Congress when they stood against H.R. 1, and when Leader McConnell in the Senate refused to allow it to come to the Senate floor. And they've made the decision apparently again now in the 117th Congress to stand against this and then tag it as being partisan, because there are no Republicans, at least at this moment, that are standing up to support this bill. I reject that formula for judging partisanship. My North Star on that is to look out into the country and, frankly, as a practitioner, to listen to what my constituents are saying, regardless of their political affiliation. And when you do that, you understand that this is not a partisan bill. In fact, there's nothing in this bill that's particularly controversial when you present it to members of the public. The only controversy, the only expression of frustration you get when you share the bill is, why is it taking so long for us to get to the point of actually getting this enacted into law? And that's why we have to, I think, seize the opportunity that's before us now. I do not think this is an instance in which we can do this now or do this later. I think this very much may be a case of, if we don't get this reform in place at this moment when we have the opportunity, we may not get the chance again for a long time to come. And that is why we are moving with all deliberate speed. And it's also why I'm very much saying to all comers, including to my colleagues in the House and colleagues in the Senate, that it is critical to keep the package together, not just for the benefit of its resonance out in the public, which I mentioned, but because it helps to address the different equities within, in this instance, the Democratic caucus, because I think that's the group of lawmakers that's going to have to carry this over the finish line. The different pieces of this bill, depending on what part of the country you represent, what district, what state, there's a different resonance depending on which part you want to lift up. In some places, it's the voting rights piece of the bill that's the most compelling and is the one that's getting real attention. In other places, it's the anti-corruption dimensions of the bill, the ethics reforms, the campaign finance reforms that are the leading argument to get this over the finish line. But together they create a gravitational pull, which I think is very powerful and is ultimately going to be the key to our success. Before I close here, let me just quickly acknowledge some other key pieces of legislation that HR 1 relates to. One is HR 4, the John Lewis Voting Rights Advancement Act, which would restore key parts of the Voting Rights Act of 1965 in terms of pre-clearance and establishing a coverage formula again that can pass muster relative to the Supreme Court. That process is underway as well. So HR 1 and HR 4 are on different tracks, in large measure because HR 4 requires an extensive record to be built in order to establish the predicate for the changes that would be proposed. So that has to move on a different timeline that's separate from HR 1, but they very much interrelate in terms of protecting access to the ballot box. And another key voting reform is HR 51, which would establish statehood for the District of Columbia. You put those three bills together, and you're talking about a robust effort to lift up the voices of Americans and make them feel confident that their voice does matter in their own democracy. Very quick on the state of play, where we are right now. HR 1 has passed the House on March 3rd and is now in the Senate. In fact, next Tuesday, the Senate Rules Committee, led by Senator Amy Klobuchar, will be marking up that bill. So that's an important milestone along the way. We very much feel and believe that getting this done in the coming weeks, not the coming months, is critical, certainly before the August recess, to keep that momentum going. And as I'm sure some of the experts that will speak to this will emphasize, many of the key reforms in the bill, including the voting reforms that are designed to respond to this unfortunate stampede towards voter suppression that we are seeing across the country that Vince alluded to at the outset. Many of those reforms can be implemented in time for the 2022 midterms, which would be a great statement back to the American people, but only if the bill becomes law sooner rather than later. So urgency is critical here. Keeping the bill together is critical. I'll just close with this. I think last November, what we saw essentially was the American people reaching out, pulling their democracy back from the brink, fighting their way to the polls in order to do that. But on January 6th, with the attack on the Capitol, I think it became clear that what we pulled back from the brink is still very fragile, in need of a lot of care and attention and fortifying. We very much believe that HR 1, S1, the For the People Act can do that. And that's why we're pushing as hard as we possibly can to get this done. Vince, thanks very much for the opportunity. I can take a question or two if you'd like before we move to your panel.
Sure. John, thank you so much. It was really great to hear from you on this extraordinary piece of legislation. And as you mentioned, it's sweeping and it's addressing concerns that I think Americans across the political spectrum have been concerned about. Maybe one question as we wrap up. You made a really interesting point about engaging the American people around this bill and sort of trying to cut through all the noise and getting them to understand that this is a lot of common sense reform. But we also know that many of our fellow citizens are being dragged in other directions, to believe otherwise, that allowing more people to vote is actually undermining the security of voting. So given how tightly balanced the Senate is and given how divided the country is politically, what do you think is there any one or two things you think would kind of break the logjam in kind of getting that message out so that perhaps we can convince a couple of people across the aisle on the Republican side to join with you on this?
Well, I'm going to be very honest with you. I think it's going to be difficult in this moment because the narrative, particularly around voting, is so highly charged right now. There's not a lot of middle ground there. And as I say, I think the Republican leadership, certainly on the Senate side, has made a calculation to kind of double down on the current playbook that they feel has been successful. And that's why you're seeing that resistance. All we can do, and we try to do this every single day, is to point lawmakers on the Republican side of the aisle to what the polls are telling us and should be telling them about what their own constituents feel. And yes, there are people that are quite gathered around the notion of voter fraud being kind of the dominant element of voting risks in the country these days. We don't see any evidence for that. There's nothing statistical that supports it, but people have gotten worked up around that. But I think still the broad majority of Americans favor the reforms in the voting space that we're proposing. And in fact, when I was debating the bill about a month and a half ago on the House floor, I took the time, and I didn't do it, I don't think I was doing it sort of facetiously or sarcastically. I took the time to thank Republican voters around the country who took advantage of all these various modalities of voting. I mean, Republican voters in the millions used absentee ballot voting. In fact, a lot of them used it in Florida and have been using it for many, many years. They used the early voting opportunities. Many are in states where they benefited from automatic voter registration and other things that just protect the freedom to vote in America. So those should not be controversial. And I think the average American voter out there of any political stripe understands that those things ultimately can benefit them and their democracy and lift up their voice. So we're just going to keep pointing the lawmakers back to what we think that fundamental reality is. And hopefully that may bring a couple of people behind this. If not, then yes, we are looking at potentially filibuster reform as being a prerequisite to getting this done. And that's another highly charged topic that I won't weigh into given the time constraints here. But I'll just say this. If there is the will, and I think absolutely the will to get this reform done is out there in the country. When people learn about what's in this bill, they say that's exactly what we've been calling for years. So if there is the will, there's got to be a way. And we need to find a way to get this done and get it done quickly so we can hand back to, what Americans did in November was they went out and they, like I say, in a sense, rescued the democracy, pulled it back from the brink. And now lawmakers have the responsibility to show we're up to the task as well, that we're ready to stand up and do the right thing for the democracy and form a partnership with the broad public to get these fundamental components of our democracy back to the full strength where we need them. So thank you very much for the opportunity.
Well, thank you, John, for that really wonderful opening for us. I can't think of a better way to start this day's events. Representative John Sarbanes from the state of Maryland, we're really, really pleased to have you with us today. And we look forward to seeing how the bill progresses and to working together as citizens to accomplish the goals that you've set out in this legislation. And with that, I'd like to pass it to my colleague, Erwin Chemerinsky, who is the president-elect of the AALS, to introduce our next panel.
Thank you, Vince. It's an enormous pleasure for me to be a part of this conference. I want to extend my great thanks to Judy Areen and to Vince for all that they've done to make this such a terrific conference. Following directly from what we just heard from Representative Sarbanes' outstanding remarks, the appropriate place to start the day is by looking at congressional legislation to protect the electoral process. And we have 5 wonderful scholars to offer views on this topic. With apologies to them, I'm going to do very short introductions. It really would take most of our time if I went through all of the qualifications and publications, and we're all here to listen to them. So I'll introduce all of them very briefly, and then we'll hear from them in turn, and then there will be a few minutes left for questions at the end. The first speaker will be Guy Charles, the Edward and Ellen Schwartzman Professor of Law at the Duke University School of Law. The second speaker will be Ned Foley, the Charles W. Ebersold and Florence Whitcomb Ebersold Chair in Constitutional Law and Director of Election Law at Ohio State University, Moritz College of Law. The third speaker will be Rick Hasson, who's Chancellor's Professor of Law and Political Science at the University of California, Irvine School of Law. Rick will be followed by Lisa Marshall Manheim, the Charles I. Stone Associate Professor of Law at the University of Washington School of Law. And finally, we'll hear from Brad Smith, the Josiah H. Blackmore II and Shirley Null Professor of Law at Capital University Law School. My thanks to each of the speakers for taking time from their busy schedules, and we'll start by hearing from Guy.
Thank you, Erwin. It's a pleasure to be here. So my comments actually follow fairly directly from Representative Sarbanes' introduction. What are the reforms that Congress can implement? From my perspective, it's fairly straightforward, which is to pass for the People Act. So I will take the next few minutes to make the case for why this comprehensive omnibus federal regulation is both necessary and timely. From my perspective, I think HR 1 or S1 or for the People Act addresses what I view as 2 fundamental deficiencies of the American voting rights framework. Per our constitutional framework, voting qualifications with some explicit limitations such as race, gender, and age, and voting administration are both a creature of state law and state practice. Now, this might make sense with respect to state elections, but it makes less sense with respect to federal elections. So with respect to voter qualifications, Article 1, Section 2 provides that the House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors in the most numerous branch of the state legislature. And with respect to state practices, Article 1, Section 4 provides that the time, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But of course, Congress may at any time by law make or alter such regulations. This decentralized approach to both qualifications and practices allows the states a great deal of discretion. And sometimes decentralization is good, and sometimes discretion is useful. But for the most part, in the American context, discretion and decentralization has also served as a conduit for discrimination, racial discrimination, as well as partisan and ideological discrimination. Fundamentally, our constitutional structure does not really reflect the reality of how a modern democracy operates. And so what a statute such as HR 1 does is that it modernizes our electoral practices, and it removes the unnecessary discretion that enables the states to engage in a war of attrition. So instead of convincing voters on the basis of policy as to what the justification to vote for them, we change the electoral rules as a way of acquiring and maintaining political power. And this has to stop. So as a function of our current framework, a citizen's access to the franchise would really be more or less a function of the state's internal preferences as well as external constraints. And the Constitution imposes a limited set of external constraints, and the internal preferences for political, ideological discrimination will vary from state to state. And this is one of the reasons why we see the types of race to the bottom with respect to disenfranchisement in the states that we are currently seeing. So now enter H.R. 1, which from my perspective is really a voting rights act for the 21st century, which does a number of things that ought to be lauded. And here I'll focus on my time just on the voting rights portions. H.R. 1 modernizes our voting rules, limits state discretion, recognizes that voting is a constitutional right, and in fact, it says explicitly the right to vote is a fundamental right of citizens of the United States. It focuses on making the right accessible. A right to vote is hollow if it is not accessible. And this has been a major deficiency of the American electoral system. It has a number of really important structural features. It shifts the burden from the individual to the state. It centralizes important aspects of election administration. It standardizes voting practices. As I mentioned, it limits state discretion and it expands the electorate. Fairly quickly on some of those features, an important move is the recognition of this bill that it is the responsibility of the state and the federal government to ensure that every eligible citizen is registered to vote. This is a significant shift from the current voting wars that we have today, where instead of fighting to undermine the right to vote, we recognize that from a normative, ideological, and cultural matter, that it is the government's responsibility to ensure that citizens have the right to vote. And additionally, there are certain sets of aspects of election administration and voting practice that ought to be centralized. That decentralization has a role, but it ought to be balanced appropriately with centralization, such as making it harder, for example, for voters to be registered in more than one state. So that way, states can't then easily disenfranchise voters when on the grounds that we think that you're registered in a fairly different state, or what the statute may do with respect to redistricting reform. It standardizes certain aspects of voting practices with respect to online voter registration, early voting, same-day registration. We know that there are certain best practices, and the question simply is, why not standardize those best practices over jurisdictions? It expands the electorate, making it easier for voters with disabilities, Native American voters, voters with Americans with previous conviction, of younger voters to access the ballot. It provides funding to states, right? So a number of really important reforms. Now, before I close, let me then address two questions. One is whether we ought to worry that this is an omnibus bill. And I think those arguments are overblown, that there are few opportunities for fundamental reform in American democracy. And once those opportunities come, we must take them, because it is the chance to really move the ball forward and to modernize our electoral practices. The second is the question of congressional power. And here I'll rely on my friend and colleague, Professor Tolson, who is the expert here. I've learned so much from reading her work, and she has more than convinced me that Congress has broad powers under the Elections Clause. She's the expert in this area to regulate times, places, and manners of congressional elections, that the Constitution is given Congress the authority under H.R. 1 to do so many of the things that the statute wants to do. So with respect to policy, with respect to ideology, with respect to congressional power, with respect to the modernization of our electoral practices, the best thing that Congress can do, and the best thing that I think we can do as citizens, is to support these types of moves that brings American electoral practices from the 19th century quickly through the 20th century, but more importantly to the 21st century. Thank you.
So I'll jump in and I'll start by sharing my screen so I can pull up my slides here. So my paper for this conference argues that Congress should pass a statute that requires candidates to receive a majority of votes in order to win a congressional election. Many Americans think that's probably already the rule, but in fact, in most states, you don't need a majority. All you need is a plurality more than any other candidate, which might not be a majority. Now, the paper explains why, in general, that shift from plurality winners to majority winners would make a tremendous difference in a wide variety of circumstances. But for today's presentation, I want to focus on one feature of the argument, which is this congressional rule would jumpstart experimentation in the states and allow states to experiment with different forms of achieving majority winners. So here's the statute that I propose. We're not going to read it all. It's short. The point here is that it actually fits on one PowerPoint slide. It's not 800 pages like HR1 S1, but for a very simple change in the rule, it would achieve tremendous effects, including this catalyst for experimentation that we really need. So let's look at different electoral systems. Again, the one that's most prevalent right now is often called first past the post. We start with a partisan primary and then have this plurality winner general election. There are in existence in states some majority systems already. I'm just going to focus on a couple of them. One is what California uses, their top two system, which starts with a nonpartisan primary, mixing Democrats and Republicans and other candidates together, sometimes called a jungle primary. And the two candidates that receive the most votes in that primary move to the November general election. Another system you may be familiar with, ranked choice voting. There are different versions of it. Maine uses one version. The version that I'm going to focus on today is Alaska's system because it builds off of California. It also has a nonpartisan primary, but instead of identifying two candidates for November, it identifies four. So there are four candidates on the general election ballot, and then ranked choice ballots are used to pick a single winner from those four. The mathematical calculation that picks the winner from those four candidates is called instant runoff voting. And we're going to contrast that instant runoff voting methodology with something that Ohio State we're calling round robin voting. So again, we're going to compare Alaska's version of its top four system with instant runoff voting to this new idea we're calling round robin voting. Now this draws on work from two Nobel laureates, Eric Maskin and Amartya Sen, but we've added a couple of features that we think are distinctive innovations that we'll explain. All right, now the reason why we're looking at these different systems is we want to tackle the problem of polarization in American politics that I think that we're all incredibly familiar with. And this slide from the Pew Research Center really illustrates this. You know, decades ago, the American electorate was essentially like the typical bell curve. Most voter preferences were towards the center of the political spectrum. But Americans literally have been pulling themselves apart, becoming more polarized towards the extremes of the political spectrum, you know, as we see here. And any electoral system is going to have to take voter preferences as they come, right, and accurately translate what voters want into a winner. But what we don't want is electoral systems that exacerbate polarization, that achieve results that are even more extremist or even more polarized than what the voters themselves want. So to illustrate this, we're going to come up with some numbers. And this is designed to be a model for what might, be existence in reality. We think that this is a good indication of what's going on given current polarization. So imagine a right of center state, a state that leans a little bit to the right. My own state of Ohio would be an example, Missouri, Indiana, Iowa, any state like that. Given increased polarization, we could see a profile of the state's electorate, something like this. So about a third of the electorate is enthusiastic for Trump or a Trumpian candidate. That's where the energy is right now on the right. Likewise, the energy on the left is with the progressive movement, AOC or AOC type candidates. Sure, there's still some centrist voters. In Ohio, there's still voters who like Senator Rob Portman, or in Missouri, Senator Roy Blunt. There are just fewer of them. And on the left, in a state like this, there'll be voters who want a centrist, more centrist Democrat, what we thought of Joe Biden as being, in contrast to, say, Bernie Sanders or AOC. So what we now want to do is map those voter attitudes into preferences among candidates. And so, starting with that group of voters, about 30%, whose first choice is a Trumpian candidate, let's just assume that their choices, their preferences are linear. So their least favorite candidate would be at the other end of the spectrum, the progressive. Likewise, on the left, the voters, the quarter of voters who most prefer a progressive candidate, moving left to right, would least prefer a Trumpian. That's a little bit more complicated in the middle. There'll be a group of voters whose first choice would be somebody, a traditional Republican like Rob Portman, but they're going to be loyal to the Republican Party, so their second choice would be a Trumpian candidate over any Democrat. And likewise, the more centrist Democrats, their first choice might be a Biden type, but they'll vote for an AOC progressive over any Republican. But there are going to be some crossover voters. We've already heard about a cohort of the electorate, sometimes called the Biden Republicans. These are voters whose first choice would be a moderate Republican like a John Kasich, but they would vote for Joe Biden over Trump or a Trumpian type. And then there'll be a slice of the electorate whose first choice would be a centrist Democrat, but they'd actually cross over and vote for somebody like Kasich instead of somebody that they perceive as too left, too socialist, or what have you. So that's our electorate in this type of state. And so now we're going to try to figure out how the different electoral systems would handle voters with these preferences. So first, let's take the typical first past the post system, which starts with a partisan primary. So we're going to ignore the left side of the spectrum and just the Republican voters in the primary. And given polarization, the Trumpian candidate is going to beat the traditional conservative in the primary and move on to the November ballot. Likewise, in the Democratic primary, the progressive is going to beat the liberal and get to the November ballot. And in the general election, the Trumpian is going to beat the progressive, most likely something like 55 to 45%, given this set of voter profiles. Now, I'm holding turnout constant between the primary and the general. That's a bit artificial, but in fact, we all know that because turnout is lower and more polarized in the primary, the reality of the situation is even worse than the model that I'm presenting today. So what about the other systems? Let's start with the California top two system. Again, we're going to take the exact same set of voter preferences, but apply the top two methodology. So they look, they look at voters' first choices, right? The only thing asked in the nonpartisan primary is who's your favorite candidate. So with voters having this profile, the top two candidates are going to be the Trumpian and the progressive, and the liberal and the conservative are going to get knocked out. So once again, in November, the Trumpian is going to win the votes from the right, the progressive is going to win from the votes on the left, and we're going to end up with the same 55-45 result. Okay, what about Alaska's instant runoff voting system? How does that work? It's again, same set of voter profiles. Well, what instant runoff voting does is it starts by looking at those first choice preferences of the voters, and it eliminates the candidate with the smallest number of first place preferences. So that's going to knock out the liberal, and then it's going to redistribute those ballots to the other candidates. So more of them are going to get redistributed to the progressive candidate. That's going to be this group of ballots, but there's going to be some that are going to get redistributed to the conservative. So after that first distribution, this is what it looks like in instant runoff voting. Nobody's yet above 50%. So the math of instant runoff voting identifies the candidate in last place. That's now the conservative. So the conservative is going to get knocked out and with ballots redistributed. So here, again, once you knock the conservative out, the Trumpian is going to pick up the Trumpian candidate is going to pick up these two groups of ballots. There is going to be a slice of ballots that's going to go to the progressive candidate. But the upshot is going to be that the Trumpian beats the progressive, same result, 55-45%. So now let's compare this new idea that we're calling round robin voting. And we call that because it replicates or emulates a round robin competition that we're familiar with from sports. Each competitor in the field has to go head to head against every other competitor to see who is the strongest in the field. And again, in sports, many examples, one from college football, the Big 12 Conference, the regular season is in essence a series of round robin competition as each team plays every other team. They form standings and there's a championship game among the top two teams based on the round robin competition. I want you to keep that model in mind as we apply this idea to elections, but there are other examples. World Cup soccer, for example, uses a round robin tournament as the first stage of its competition. So how would this work in the context of an election? Again, we're taking the exact same state with exact same voter preferences. Indeed, we can take the very same ballots that Alaska uses. These are the same ranked choice ballots with the same rankings of the candidates among the same group of voters, and we can create round robin competition from those ballots. How does that work? I'm going to give you a couple of illustrations. If you have 4 candidates, you're going to have 6 head-to-head matches. That's just the way the round robin math works. And so let's do the first one. Let's have head-to-head the Trumpian candidate against the conservative. It means we ignore the other 2 candidates for this matchup. And we see that among all the voters in the election, it turns out that the conservative beats the Trumpian 69-31%, because all of these voters on all of these ballots prefer the conservative to the Trumpian. It's only the 31% that are all in on Trump and his movement that prefer that candidate. So this is a pretty decisive 69-31 majority win in that head-to-head matchup. What about when it's the Trumpian versus the liberal? Again, we ignore the other 2 candidates for this round robin face-off, and we see that the liberal beats the Trumpian on these sets of ballots. Not as strong a victory, but it's 55%. The Trumpian here picks up the original 31 plus this cohort of voters for a 55-45 matchup. Again, we could run through all of them, not going to take the time to do that, but at the end of your round robin competition, you get standings like in football or soccer. And it turns out that the conservative candidate wins all 3 of the head-to-head matchups. The liberal wins 2 out of 3, the Trumpian only 1 out of 3. What's the upshot of this? If we substituted round robin math for instant runoff voting math in the Alaska system, the winner would be the conservative candidate, not the Trumpian candidate. In other words, round robin analysis identifies a different, stronger majoritarian preference than what instant runoff voting does from the exact same preferences, the exact same ballots. But I actually think there's a better use of this round robin analysis, and that's to use it in the nonpartisan primary phase of the California system. In other words, what California wants to do is to figure out who are the 2 strongest candidates in a field of candidates to put those 2 finalists on the November ballot. Well, the better way to identify the 2 strongest candidates is not do what California does and simply says who gets the most first place votes. It's instead is to construct this round robin competition where all candidates to compete against each other. And it turns out that your 2 strongest candidates are the conservative and the liberal, not the Trumpian and the progressive. So using the round robin analysis in the primary phase would in essence replicate what the Big 12 conference does in football. First round robin, then a championship general election. All right, the key insight here, I think, is that for this type of state with this type of voters given polarization, the 3 existing systems all think the 2 most polarizing candidates are the strongest, with a Trumpian candidate beating the progressive. But it's the round robin analysis that yields the insight that when all the candidates have to go head-to-head against each other, the 2 strongest candidates are actually the conservative and the liberal. And if those preferences hold through the general election campaign, the conservative would be the winner. So again, the paper concludes that Congress should require majority winners because in a wide range of circumstances, any majority system would be better than the plurality system. But a key point is that Congress should have this experimentation among majority systems occur in the states because it may be that states should experiment with different systems, including the possibility of using round robin voting as a way to attack and combat polarization and extremism. Thank you.
Thanks, Erwin, and thanks to AALS for convening this event. I'm very glad to be with you. I'm glad also that I've followed after Representative Sarbanes and Guy and Ned, who I think all presented kind of aspirational views as to what Congress might accomplish. I want to turn from the aspirational to realism, to what actually could potentially be accomplished by Congress in the next few months. And I think it's really important to do that because for 2 reasons. Number one, we're in a very dangerous period in American elections and democracy right now. We've come off of an unprecedented election in which a presidential candidate claimed that the election was stolen and rigged and on no basis in reality whatsoever, and convinced millions of his followers that this is a major problem in our elections. And you don't have to look any further than the fake audit of ballots that's being done right now in Arizona, and using ultraviolet light to look for strips of bamboo inside the paper of the ballots to find some supposed connection to China, to recognize what a dangerous period we're in, right? So the first reason to worry about this now is American democracy is under attack internally in a way it has never been before. And the second is that because of polarization, there's a very narrow window in which election reform can actually get through on the congressional side. It's because of Trump's hold over the Republican Party. It does not seem likely that there will be any appreciable Republican support for desperately needed election reform. And so the question then is, what can Democrats do? And of course, Democrats have very narrow majorities in both the House and the Senate. Ordinarily, legislation that doesn't go through the reconciliation process, which voter legislation would not, would require a 60 vote majority. Democrats only have 50 votes plus the tiebreaker of Vice President Harris. And so they would have to blow up the filibuster in order to pass voting legislation. And so, very small window, very good odds that Republicans take over one or both houses of Congress in the next election after 2022. So now is the moment in which election reform can happen. And so I just this morning, just before I came on, saw an article, a local article in West Virginia, in which Senator Joe Manchin was quoted. Senator Joe Manchin is someone who is not co-signed onto HR 1, who is resistant to a broad package, an 800-page bill. And so the question is, what would he agree to in any kind of compromise? And what he said this morning was that there were 3 principles at play: accessibility of polling places, fairness in the voting process, and a secure voting system. And it seems to me that if you were trying to strip down and pare down HR 1 into essential voting reforms, you'd have to do something like this. And if you look, for example, and we'll be hearing from Brad Smith later, at the opponents of HR 1, much of that fire is aimed, at least right now, at the campaign finance provisions of the law, the public financing provisions, the disclosure provisions, and all of that. The ethics provisions are in there. I'm a supporter of many, although not all parts of HR 1, but I think in an emergency, as we're in right now, where our very democracy is at stake, really Congress should focus on the key areas and look for some compromise that could get to 50+1 votes in order to pass that reform. And if that means jettisoning public financing for congressional campaigns, that is certainly a price that should be paid in order to get some kind of legislation through. So what would the features of a pared down election reform look like? Certainly HR 4, which is the John Lewis Voting Rights Act, preclearance provisions, restoring the preclearance provisions of the Voting Rights Act seems to be one of the very most important things that needs to be done. Congress has the power to enforce the 14th and 15th Amendments. The Supreme Court in the Shelby County versus Holder case didn't say that Section 5 itself, that the preclearance provision was unconstitutional. It instead said that preclearance was based on old data, and that was impermissible and exceeded congressional power. So new fact-finding, new data, and perhaps, as Senator Manchin suggested in the same comments that he made recently in this local discussion, is perhaps extending preclearance to all 50 states. And then there would be no complaining that one state or another has been singled out for special treatment, somehow undermining what the Supreme Court called the equal sovereignty of the states. So one measure would be aimed at preventing voter suppression. The John Lewis Voting Rights Act would do that by restoring preclearance. And I certainly think that that would be the kind of reform that used to garner bipartisan support and could perhaps get some Republican support, especially if it was not targeted at any one particular state. So one issue is dealing with voter suppression. Just last night or this morning at 4 o'clock in the morning, the Texas House passed a new set of restrictive voting laws that, among other things, criminalizes offering an absentee ballot application to someone who doesn't request one. I mean, we're really in a very sad period where just trying to make voting accessible could be a crime. And that's, I think, is terrible. Okay, so one thing is preventing voter suppression. The second is working against election subversion. I had a piece last week in the New York Times. I think this is a separate question from voter suppression. The concern here is about changing who decides what the voting rules are or how votes are counted in a way that election results could actually be messed with. One of the things that we saw Donald Trump trying to do in the aftermath of the 2020 election was trying to get either state legislatures to overturn Democratic results in the states, or try to get election officials to claim that the election was somehow fraudulent. We had the famous phone call with Brad Raffensperger, who was the Secretary of State of Georgia, to try to get him to so-called find 11,780 votes and give him a 1-vote victory over Joe Biden. Since that has happened, Georgia's law that was passed that got so much attention for voter suppression actually allows for takeover of Democratic counties like Fulton County for partisan purposes. It allows for more partisanship on the election board. We're seeing all kinds of rules that would allow poll watchers to interfere with the actual counting of ballots. And so I think Congress needs to pass laws that promote this kind of election integrity, that promote this kind of secure ballot. One thing that's in HR 1 that should be passed is paper ballot requirement for every state. That is, every state's voting system should produce a piece of paper that can be recounted, that provides some tangible evidence that could be used in case someone is trying to mess with election results. And the final piece, and this is the last point I'll make before turning it over to Lisa, is to deal with bolstering Republican moderates. And this fits in exactly with Ned's prior presentation. What can Congress do? Ned was talking about things like requiring something like instant runoff voting top 2 or some variation of this to try to bolster moderates. Well, one thing that's already possible and already in HR 1 is requiring states to use redistricting commissions to draw congressional districts. And that is a way that Republican moderates and Democratic moderates could be bolstered. Why is it important to bolster moderates? Because it is these moderates who are most likely to hold the line on the rule of law. And so this is a very different kind of battle than we've seen in the last, period of American history. In the 1950s, the parties were, very similar to each other. We then moved into a period of polarization, but where there was honest competition. And now we're in a stage, because of the rise of this Trumpian moment, where I think honest competition in elections is under pressure. The repeated claims that the election was stolen has provided a basis for trying to manipulate not just who in the electorate can vote, but how votes are counted. And it's the kind of moment I never thought we would see in the United States. And I was actually speaking to a reporter the other day, what would be, the standards that states should apply. And I said, go to the Carter Center, look at how the Carter Center comes up with rules for emerging democracies. And those are the rules that we're going to have to apply to our states to make sure that they are following basic principles of fairness. Things like allowing observer and press access to how votes are counted, transparency in what the rules are for counting ballots, those kinds of things, and fair access of all the candidates to understanding the machinery of the election. And so it's very sad that that's where we are now, but I think we have to put our efforts not into a kind of grandiose bill like HR 1 that doesn't have a realistic chance of getting through this Congress, but instead do triage and ask, what can we do right now to help save our American democracy? Thanks so much.
Thank you so much to Erwin and also to my colleagues on this panel and to AALS for the opportunity to join the discussion today. What I'm hoping to talk about overlaps a little bit with what Rick has been talking about, and that's because I'd like to talk about some of the challenges that face not only HR 1, which Representative Sarbanes and Guy discussed, not only a majority rules proposal like the one that Ned discussed or the many sort of sensible reforms that Rick just discussed, but the hurdles that are facing any attempt at reforming the electoral system through Congress. But I don't want to bring these challenges up for the purpose of suggesting that Congress is an inappropriate institution to turn to. To the contrary, I want to flag these problems for the purpose of suggesting that in the world of election law right now, we are facing a situation where it's not going to be enough just to turn to Congress, far from it. So what are some of the serious problems facing any attempt to reform the system through congressional statute? I would say there's at least 3. First, finding a way of turning that bill into a law, just getting it through the legislative process. Second, judicial review. Any statutory reform in this area is almost certain to trigger a whole slew of constitutional challenges. And then third, ensuring that the law is actually then followed, by which I mean to say ensuring that the rule of law itself is maintained. So this first problem, getting any of these statutory reforms through the legislative process. Again, Rick touched on this and I totally agree. This is always hard to do, particularly with respect to congressional legislation. But one of the biggest problems here is that we have people in positions of power, including people in Congress, who are benefiting from the dysfunction in our electoral system. More generally, they are benefiting from sort of the anti-democratic energy generally that we've been seeing. So it's not in their interest to fix the system. They don't want to. And this sort of entrenchment, and by entrenchment here, I mean to refer to when officials try to manipulate the electoral ground rules in order to stay in power regardless of voter preferences. Entrenchment of this sort is always a problem in election law. And it's one of the reasons why it's so hard to get meaningful election law reform through, much less to get it through on a bipartisan basis. And the punchline here is that it's going to take enormous political pressure to convince Congress to act on HR 1, HR 4, a proposal like Ned's on any of these issues. So the second problem that's going to be facing any attempt at congressional reform is going to be related to constitutional challenges. So to that end, here's one data point. In March of this year, 20 state attorneys general wrote congressional leaders about this big pending election bill that we sort of keep talking about today, HR 1. In the letter sent by these state AGs, it began with constitutional objections to the bill, and it ended with a promise to sue. Now, how will these challenges fare? Not just against HR 1, but against, if HR 1 somehow passes, but against any congressional legislation. So we actually don't know, and that's because a lot of the implicated doctrines are unsettled. But if what we're talking about is meaningful structural reform to the way that states run elections, and this is reform that's enacted through congressional statute, then there are definitely going to be a range of non-frivolous constitutional challenges to bring. At a high level, for example, what enumerated power allows Congress to pass this provision, or what principle of federalism allows Congress to interfere with states' rights with respect to that provision. Surely the Supreme Court, as it's presently constituted, is going to agree with at least some of these challenges. And so as a result, even if meaningful statutory reform somehow gets through Congress, it's immediately going to head to the courts, which are going to chip away at the reform in whole or at least in part. So this gets us to the third set of concerns. So even if these laws are in the books, even if the court signs off on their constitutionality, how do we make sure that the laws are actually followed? How do we make sure that the rule of law is maintained? And this is something, of course, that as lawyers, as law professors, we so often take for granted. But particularly over the last 6 months or so, we have seen on full display the willingness of some in power to subvert the rule of law. So we've seen calls to disregard the law on entirely pretextual grounds. We've seen repeated and concerted rejection of facts and fact-based discourse. We've even seen violence, and we have seen insurrection. So it's this last set of hurdles, these threats to the rule of law itself, that in some ways is the most unsettling. And it's among the most difficult for lawyers to be able to respond to. Without the rule of law, the US Code, of course, is quite constrained in what it can accomplish. So now this is the part of an academic presentation where I'm supposed to pivot and say, in light of these challenges, we shouldn't be looking to Congress. Instead, we should be looking to some other institution or set of reforms. We should be looking to state legislatures or to the courts or to private law or norms or just to voting or whatever. But I can't do that. And the reason why is because in response to the sort of collection of overlapping pressures on election law that the country is facing right now, there is no silver bullet. Any of these other approaches are also going to implicate significant hurdles. But as the others on the panel have suggested, and I very much agree, when it comes to these issues, when it comes to maintaining the rule of law, when it comes to maintaining the electoral system that both undergirds and also depends on the rule of law, the stakes here are so high that we have to do something. We can't just sort of let this one go. Okay, so should we be turning to Congress? Yes, but that's not going to be enough. Instead, we need all hands on deck. In terms of what that looks like, this is to some extent unprecedented, but we actually do have, in a sense, a very recent precedent, and that's the precedent that was set by the 2020 elections. So out of the 2020 elections, there was not one person or one institution or one party that dragged us through what ended up being, against increasingly steep odds, a successful law-based transfer of power on January 20th. Instead, what we saw, in the words of a journalist, Molly Ball, what we saw was a vast cross-partisan campaign to protect the election, an extraordinary shadow effort dedicated not to winning the vote, but to ensuring it would be free and fair, credible, and uncorrupted. And as she goes on to explain, for more than a year, a loosely organized coalition of operatives scrambled to shore up America's institutions as they came under simultaneous attack from a remorseless pandemic and an autocratically inclined president. Though much of this activity took place on the left, it was separate from the Biden campaign, and it crossed ideological lines with crucial contributions by nonpartisan and conservative actors. So we saw these efforts. We saw these efforts before the election, we saw them during the election, and we saw them after the election. These efforts, we saw them with activist groups, we saw them with partisan actors, election officials, people in the media, academics, courts, businesses, and more. And collectively, it was this effort, this extraordinary, this exhausting, but this extraordinary effort that did ultimately work, at least for now. And this is the sort of effort that we are going to need going forward. For a host of reasons, congressional legislation is not going to be enough. And in fact, I would say no single pronged approach is going to be enough. So when we start to look at election law reform through this lens, we see that the implications are vast. To affect, support, accompany congressional reforms, we're going to need a lot of things. We're going to need at sort of a high level promotion of fact-based discourse. This might include reforms to help support independent, reliable, fact-based media and educational outlets. It also may include reforms to discourage companies and others from exploiting conspiracy theories and extremist movements to make money. We also are going to need support, a lot of support, financial and otherwise, for institutions that help to maintain the rule of law. So this includes support for election officials, support for courts, support for schools. We're also going to need brainstorming of the sort we're hearing today about democracy enhancing reforms at every level, legislative, executive, judicial, federal, state, local, public, private, and so on. Now, within this sort of world, we all have our things that we're sort of particularly focused on. For example, in my end, I'm particularly focused on right now this phenomenon that I refer to as electoral sandbagging. And the idea there is that it sort of comes out of civil litigation, where you have this practice where a trial attorney will sort of let some error occur at the trial, or even will deliberately cause the error to occur, and then on appeal, we'll point back to that error to say that there should be some sort of relief going forward. And what we're seeing in the election law space is an analogy to this, right? So we have it where basically people in charge of election systems are sort of deliberately causing problems and then pointing to those problems that they've caused for some sort of self-serving end at the back end. And so I see this, and I feel like it's extremely problematic. It's corrosive to the system. It's inconsistent with democratic governance. And I would love congressional legislation to discourage this practice. That being said, my own sort of more narrow interest in this phenomenon is set against, and I think it has to be set against, a broader understanding that focusing on discrete issues alone is not going to be enough in light of the challenges facing the country. So I guess what I'll say to conclude, and then I'd love to sort of turn things over to Brad. So what we need to be thinking about is not just sort of big picture phenomenon like the electoral sandbagging that I discussed, but also simpler problems like burnout among election officials across the country. We need to be thinking about the implications of political pressures that are facing congressional leadership, like we're talking about now. We also have to be thinking about the implications of death threats that are being received by election officials in Washington state. The composition of the U.S. Supreme Court, it really matters. The composition of high school civics textbooks and curriculum also matters. It's an enormous set of overlapping tasks. This all being said, for all of the sort of bad news and problems coming out of the 2020 elections, I would again say that it does offer a glimmer of hope going forward. In response to this extraordinary set of challenges, people committed to the rule of law did come together and manage through a cooperative, cross-cutting effort to ensure a successful transfer of power. And we're going to need that same sort of vision and effort going forward.
Okay, well, thank you. Thank you, Erwin, and thank you to all my fellow panelists. I get the pleasure of closing out, I guess. So I want to suggest that the dominant problem in U.S. democracy today, let's put it simply, everybody's been kind of saying it in different terms, but is the loss of faith in election results. And as my co-panelist Ned wrote recently in the Washington Post, if the losing party can't accept defeat, the whole enterprise of electoral democracy is finished. We're not talking about confidence in the responsiveness of government or the willingness of government to do the right thing. We're talking about trust in the basic accuracy of the vote count. Now, there's a widespread belief, I think, particularly amongst, frankly, people like us, right, that this is sort of a uniquely Republican problem, a party beset by QAnon conspiracy theorists and egged on by a uniquely demagogic leader in Donald Trump. And I would not dispute that that is part of the problem, but I want to suggest that it's a bigger problem than that, and it's a worse problem than that. And it is, in fact, a bipartisan problem. So to make that point, my comments for the next few minutes are going to focus almost entirely on the Democratic Party. In doing so, I'm taking it for granted, if you will, the problems that are there in the GOP and so readily apparent. Nothing here that I'm going to say should be taken as an apology for January 6th or some whataboutism. I'm not drawing equivalencies. Rather, again, I'm trying to suggest that the problem runs even deeper and won't be solved by the disappearance of Donald Trump from the scene or even by a few Republican victories in a national election. Let's start with counting electoral votes. In each of the last 3 Republican presidential victories, Democrats in Congress objected to the electoral vote count. Over a dozen House Democrats objected in 2000. In 2004, 31 House Democrats, along with Senator Barbara Boxer, objected to the electoral vote count. In 2016, Democratic objectors included my friend, Jamin Raskin, who many of you know, a former election law professor, and Representative James McGovern, who was chairman of the House Rules Committee that drafted the articles of impeachment after the January riot at the Capitol. Among those states whose electoral votes were contested were Alabama and Wyoming, states Trump won by 28 and 46 points, respectively, margins far beyond any possible fraud, suppression, or irregularities. And yet, Democrats in the House contested these, kind of sending the idea that this is a legitimate act to do by Congress if you're just unhappy with some minor element of the election. Nancy Pelosi at the time did not join the protest, but she did state, "I will support those who object." Since 2016, prominent Democrats, including Hillary Clinton, former Senate Majority Leader Harry Reid, have continued to claim, without evidence, as the saying now goes, that Russians manipulated the votes. That's an exact quote from Harry Reid. Not that there was Russian influence attempting to buy ads on Facebook, that they manipulated the votes, or Hillary Clinton stated that they hacked the computers in Florida. And these statements have no evidence in support. A poll by The Economist, or for The Economist, found that 52% of Democrats falsely believe that it is either definitely or probably true that, quote, Russia tampered with vote tallies in 2016. Note the specificity of that finding, not just Russian interference in some vague sense. A University of Chicago poll taken shortly before the 2020 election found that 62% of Democrats believe that voting systems would be used to tamper with election results. Again, that's an exact quote of what those respondents were asked. Another October 2020 poll found that 45% of Republicans believe that if the other side won, it would be at least somewhat likely due to fraud. But that same poll found that 44% of Democrats, a 1-point difference, believe the same thing, that if Democrats lost, it would be due to fraud. And while 70% of Republicans believe that mail-in ballots would be used to, quote, rig the election, nearly the same percentage of Democrats believe that the U.S. Postal Service would attempt to, quote, rig the election by refusing to return marked ballots. And in October 2020, Joe Biden himself stated that he could only lose if there was some type of vote tampering or chicanery. It's not just in presidential races. Stacey Abrams, who lost the 2018 Georgia governor's race by over 50,000 votes, continues to claim that she's the rightful winner. And far from being treated as a kook or pariah, she's a rock star in Democratic Party circles. Vice President Kamala Harris is among those who have supported Abrams' spurious claims. And for good measure, she's also added that the 2018 Florida governor's race was stolen. Since 2000, the percentage of Americans expressing confidence in the accuracy of the national vote count, as expressed in various polls, has declined precipitously from well over 50% to something typically in the range now of 20 to 30%, depending on the poll. This decline is most pronounced amongst Republicans, but note that this very large drop in Republican confidence has merely brought the parties into rough equilibrium in the percentage of their adherents who believe that they have confidence in the national vote count. Further, most of that drop in the Republican side occurred between 2000 and 2012, before the arrival of Trump on the scene. According to Pew, entering the 2020 elections, Pew polling, there's, quote, no partisan divide in confidence in the vote count across the country. Now, there's much more, but time requires me to move on. The point I want to make is simply that this problem runs deep. It exists in both parties, and it won't go away simply because Trump goes away, or even if some of the pathologies and parts of the Republican Party are resolved in at least some way, because it goes beyond the worst of those concerns. And again, it is bipartisan. Against this, what stands out to me is the irrelevance of most of the reforms being proposed in Congress. For example, one hot topic is frequently electoral college reform and constitutional amendments or national popular vote. Yet polling shows that the electoral college has been more popular over the past 20 years than it was at really any point between 1944, when Gallup first asked the question, and the late 1990s. The electoral college is actually more popular than it has been historically. Reforming the electoral college is not going to restore voter confidence in the actual counting of the results, the actual question of who won. Another pet reform, this one included in H.R. 1, is nonpartisan redistricting. Now, again, there's a case that can be made that indirectly this will bolster moderates and this will help and so on. But whatever the merits of the issue, it bears almost no immediate relation to this core crisis facing American democracy. And it's quite likely that it will make it worse. To the extent that the goal of nonpartisan redistricting is to create more competitive districts, recognize that one thing we do know is that voters are more likely to express confidence in the vote counts, that it is accurate, when their candidate wins. By increasing the number of close races, we're going to increase the number of voters supporting the loser in each election, and nonpartisan redistricting, therefore, will quite likely make things worse in terms of confidence in the actual vote count. Another old chestnut featured in H.R. 1 is campaign finance regulation, although considerable research shows that this too has no real effect on voter perceptions or confidence, regardless of what we might think about the merits of the particular provisions in the law. In terms of election administration, the types of reforms now pending in Congress as H.R. 1 are based on what I believe is an incorrect diagnosis. Now, we should note the same could be said of most Republican reforms going on in the states, where the incorrect diagnosis is that there's massive fraud, which I don't think there is by any means, but this panel is focused on Congress. And the diagnosis in Congress is that there's massive disenfranchisement in the United States. In fact, I think there have never been fewer obstacles to voting in the United States. Until 1980, no state in the country had no-fault absentee voting, and almost none did until the last 20 years. There was virtually no early voting or provisional voting before 2000. All mail-in voting is a creation of the 1990s. Over the past 20 years, turnout has gone up among Asian Americans, among Hispanic voters, among African Americans. H.R. 1 operates on the assumption that the major reason people don't vote are legal impediments and inconvenience, and the data simply don't show that. When people are asked why they don't vote, they tend to say they don't vote because they don't care and they're not interested. As a result, whatever the merits or demerits of H.R. 1, it simply fails to address this loss of confidence in the actual vote count. Unfortunately, there's almost no research into what causes people to lose faith in the vote count or what can restore that faith. There have been times when Republicans have argued, for example, that voter ID laws are valuable because they'll restore at least voter confidence in the integrity of the process. That does not seem to be the case. It seems to be something that simply does not show up in the data at all. And of course, they do very little in terms of preventing actual fraud. But recognizing this lack of data, let me offer a few tentative suggestions for thinking about reform. First, although fraud is not a serious problem in American elections, until Donald Trump went overboard with his wild claims, it would have been entirely uncontroversial to note that voter fraud was more prevalent in absentee ballots than in in-person voting. Additionally, the rejection rate is higher for absentee ballots. That is, what should be valid ballots are more likely to be incorrectly excluded when they're cast as absentee ballots. And Clearly, large segments of the public, mainly Republicans, perhaps due to Trump, are suspicious of extensive absentee voting. Equally important, in my view, is voting is a civic act. It should be performed in a public setting. And it would be a good thing if voters learn that they have to have some meaningful desire to vote, enough to put up with minor inconveniences, and to think about a bit about voting. It's not the worst thing in the world to stand in line next to your neighbors for a few minutes before casting a vote that will affect those neighbors. And for purposes of credibility, it may be good for people to actually be at the polls and see the process. This goes to Rick's comment, in a sense, about transparency. At the same time, inconveniences shouldn't be unreasonably burdensome. I recognize that there's disagreement over when an inconvenience becomes a burden, but the key point is that the norm should be that voting is a public civic act. How one votes is private, but voting should be public, and voting from home should be considered an exception to the rule. Voting by absentee should not be considered the norm or particularly encouraged. And I note that Belgium, the Netherlands, France, Sweden, Norway, and many other Western democracies entirely ban absentee voting, even for cause, for people living in the country. And given this, however, two, states must assure that all areas have adequate service in polling locations, machines, and poll workers to assure that lines do not become excessively long. If this cannot or will not be done by the state, one of the best things Congress could do would be to provide assistance through the Election Assistance Commission to funding those roles in elections. Three, reform should be simple. Suspicion in the vote count goes up when voters don't understand the process. And for that reason, I'd be very cautious about proposals such as NEDs or instant runoff voting. Although I don't really disagree with the core ideas in them, I'm not sure that that's what we want to be doing now. Four, all votes should be required to be received by the close of election day. This is an elementary anti-fraud measure. It helps prevent post-election day lead changes, which have raised suspicions of the vote count. Five, two things I agree with Rick on. So maybe here's the basis for compromise, bipartisan compromise, paper ballots, and transparency in counting. And finally, I would suggest that officials, including courts, need to restrain themselves from making changes late in the day. Sometimes it is better to let the election go forward in an imperfect fashion under rules that everybody had agreed to in advance, rather than have a court or another official step in and make changes based on some immediate crisis or need or some factor that comes up, because that's the kind of thing that opens up charges of partisanship that leaves people feeling like the rules are being gamed at all the time. I'm not sure that these proposals address the crisis either, but I think we have to restore the notion that voting is a civic act of togetherness, and we have to think of moderate reforms that aim to restore confidence in that basic idea that we can trust the count. So I'll conclude by noting the one thing I am pretty sure of. Anything Congress does do has to be the product of some type of bipartisan process, not a partisan wish list introduced with no discussion with the opposition, such as H.R. 1. In that sense, no matter what H.R. 1 contained, it would be poisoned simply because it was developed as that kind of partisan wish list on a purely partisan level. And if we want to restore confidence in the states, members of Congress, members in the state legislatures, again, this panel is about Congress, so I haven't talked about these Republican efforts in the states, but in both cases, our elected office holders have to start acting like politicians, that is, forging compromises and coming up with real solutions rather than posturing. Ultimately, the loss of faith in the vote count is the biggest issue we face and the fundamental issue to which all else is a footnote. Thank you.
My thanks to all five of you for wonderful presentations. I think I'd like to start with a question for the first two speakers and then a question for the latter three speakers. My question for both Guy and Ned is, what's possible now given the filibuster and the composition of the Senate? You've each outlined wonderful ideas for change, but I think what Rick and Lisa especially are saying is, it's just not possible. And I'd be interested in Guy and Ned for you responding.
Sure.
You want to go first?
I think there are two ways to think about this. And one way is to think about it from Brad's last comment, and then the other is from Rick's statement, which is, it is hard to think about bipartisanship if you genuinely don't have a good faith partner on the other side. I think that's just really hard, particularly if there are different ideological and partisan views on basic questions. So the basic questions such as whether voting is a privilege or whether it is a right. right? Whether people should have to make some strong effort and bear some burdens, and and people will disagree on what the burdens are, or whether the government ought to bear as much as possible, right? So where you have these fundamental disagreements about what a 21st century multiracial, multicultural, multi-democracy looks like, then the requirement of bipartisanship is, in essence, essentially saying we are not going to do anything. So where I think we are is essentially a cultural fight, a fight for sort of basic fundamental principles and rules. So even, for example, some of the suggestions that my friend Rick Hassan and my friend Brad Smith have made. So Rick's suggestion on HR 4, well, if you think HR 1 is problematic, I just can't imagine that HR 4, the return to preclearance. And so if one says, well, preclearance is going to be okay if it's nationwide, well, that just is a major federalism problem. Right? So now you're requiring all the states to subject themselves to some federal oversight, as opposed to a few of the states. It used to be the case that the court thought that what worked with the preclearance provision of the Voting Rights Act is that it limited itself only to the offending states. Right? So I think it's hard to think about when we're in a cultural moment and we're trying to think through the fundamental rules. So what matters, I think, is where we were and what can we do. This reminds me a bit of where pre-1965, where there was a lot of ferment about moving us from a world of racial discrimination to a world in which we're trying to think about how to move forward. And really the grassroots organization and protest movements moved the culture. It moved Congress, it moved the court, and it enabled the creation of bipartisanship. The Democrats had to get their act together. Republicans came along, right? So I think what we need is greater grassroots participation that will move the political process and move our institutions forward. So that way we can move beyond this cultural fight over fundamental principle.
Ned?
Yeah, thanks. Here's why I think my majority winner proposal should be realistic right now, given the current composition of Congress. I think there ought to be 10 Republican senators who philosophically agree with it and see it in their own self-interest. It's essentially a federalism proposal. It's a small congressional mandate. And the mandate is simply majority rule, which is something that's sort of intrinsic in democracy. So it's not a major imposition on the states by Congress the way HR 1 should be. It's just a modest imposition of a majority rule, which people should be in agreement with. And then it allows states to do whatever they want consistent with majority rule. That's federalism. So it's a proposal built for people like Senators Blunt from Missouri or Rob Portman from Ohio. It's no accident that we've got 5 retiring Republican senators who don't want to face MAGA-motivated Trumpian primaries. And that's a real crisis given polarization. If you take those 5 senators who are retiring, they don't need to face re-election. They just need to think, what's their legacy for the good of the country? And you can have 5 other Republicans, and my 5 would be Collins, Murkowski, Sass, Romney, and Grassley. Grassley himself may end up retiring in this round. There's 10 Republicans. The Democratic Party, as President Biden said, should want a Republican Party that believes in democracy and the rule of law. So we should have the House adopt this, Democrats in the Senate should adopt this, these 10 Republicans, Biden should sign it. This should be a very reasonable proposal. Again, it fits on one PowerPoint slide.
I want to ask Rick and Lisa, is what's possible enough to make a difference? And Rick, in answering, how would you respond to Guy where he says, there's no way we're going to be able to get pre-clearance through the Senate and pass the filibuster?
Let me take that point first. I I don't know about it getting through the Senate. If Joe Manchin is behind it and Democrats are willing to go along with whatever he says, it could get through. How it would fare at the Supreme Court, I think part would depend. And I saw Carolyn Shapiro's question in the chat about legislative findings. I think it's very important to make a record as to the problems. And I think, a fair Supreme Court that evaluates the question and understands Congress's power, not only under the Elections Clause, but also under its power to enforce the 14th, 15th, 19th, 24th, and 26th Amendments, has broad power. I don't know if the Supreme Court would accept that, but I think there is a strong argument to be made for that. I don't know if it is enough. I think so much of what will help save American democracy depends in part on other institutions, strengthening our institutions of free press, the role of non-governmental organizations, the law enforcement following the rule of law. A lot of the work has to be done outside of Congress, but this is a panel focused on congressional legislation. And so that's where I've put my focus. But certainly congressional legislation is not enough to save American democracy from the dangers that we're in right now.
Lisa, is what's possible enough to make a difference?
So this may seem sort of like a silly framing, but I know that there's this sort of thing that they teach people in improv classes, which is that if someone says something, then you're supposed to respond with yes and I feel like for law professors, for lawyers, that's not generally how we respond to ideas. We usually respond to ideas by saying, I see what you're saying, but at this point in sort of given what the country is facing, I think that we really should be in a yes and phase, which is to say, let's look at what Congress can do. If it doesn't work, let's just keep trying. Let's see what other institutions can do. The real question, I think, is one of prioritization. Obviously, we can't sort of spend all of our time working on all these different proposals. But again, this is a time to try to think about what might be possible and where we might be able to go, rather than in a knee-jerk way, sort of rejecting things as not being possible.
Brad, I'll ask you the same question, and we'll have to conclude the panel with your answer. Is what's possible with regard to electoral reform enough to make the kind of difference that you want to see?
Well, I would agree entirely with Lisa and the others that it requires more than just what Congress can do. But I do think Congress can do some things, and in response to, I would say, part of bipartisanship means you start with sort of baby steps. You start with things like paper ballots, something Rick mentioned. You start with something, I think, while again, I have some questions about whether voters would understand the round robin approach, the idea of some kind of basic statute like Ned says, I think probably could garner bipartisan support. So you need to start small rather than start large. And again, yes, it goes beyond what Congress can do, but Congress has to be part of the solution.
I have lots of questions, and I'm sure we would get some through the chat, but alas, we've come to the end of this session. Again, my enormous thanks to all the speakers for terrific, thought-provoking presentations. As the moderator, my job easy. I didn't need to ask anyone to stop. You all stayed within the agreed time limit, so very grateful for that. What happens now is listed in the schedule as a lunch break. For those on the West Coast like me, I guess it could be a late breakfast or snack break. We'll resume again at 1:30 with the panel on race and voting rights. And we'll have the introduction by Kelly Testy from LSAC. Thanks again, and thanks to all watching. We'll resume again at 1:30 Eastern Time, 10:30 Pacific Time. Thanks, everyone.
Good afternoon, everyone. I want to welcome you to the afternoon session of our conference today, and thank you so much for joining us. I'm Kelly Testi, and I currently serve as the president and CEO of the Law School Admission Council. It's been our honor to be able to co-host this with the AALS and the ABA. And I want to give a special shout out to Judy Areen and also to Erwin Chemerinsky, Vince Rougeau, and Darby Dickerson, all of whom were instrumental in the organization of this conference. LSAC was particularly thrilled to be able to be involved because, as you know, we're always out on the front lines building the future of our profession. And so to keep law, to keep democracy strong, those must happen so that we can continue with enthusiasm to help young people find their way to joining our profession. I really am delighted to be here as well personally, because before serving as LSAC's president, I had the honor of being the president of the Association of American Law Schools in 2016. And during that time, I guess it would have been as early as 2015, I chose as my theme the topic, Why Law Matters, and urged us all to realize how critical law is for the functioning and the flourishing of our world. And I pointed out then that I'd always been frustrated as the dean that sometimes it seems hard to get people to realize how important law is. And I just will share one sentence from the annual address I gave back in 2016 that noted that law can be like the air we breathe, perhaps noticed more by its absence than its presence, but we can no more live healthy lives without the rule of law in this world than we can live without air. And waiting to appreciate its vital role until we're choking and gasping is not a good strategy. It's surely not. And in the time between 16 and now, we've seen in way too many contexts how much we need to take care of law and democracy, from the murder of George Floyd to the insurrection in the Capitol, to the challenges to the basic right of voting in our world, to COVID and all the disproportionate effects it's had on BIPOC communities. So it is wonderful to see all of us coming together to focus on rebuilding law and democracy. And I'm very delighted today to introduce the panel on race and voting rights. And in doing so, to turn it over to our moderator, Heather Gerken is the Dean and Saul and Lillian Goldman Professor at Yale Law School, and she will serve as our moderator for this session today. As you all know, she's not only a fabulous dean, but a wonderful scholar in this field in her own right. And so with that, I want to say thanks to each of the panelists for being with us today. I'm so glad you're here. And Heather, it's an honor to turn it over to you, and thanks for being with us.
Thanks so much, Kelly, and thanks to everyone for organizing this just sensational conference. I know we couldn't have a more important topic than the one on this panel, and we just have a group of rock stars who've been devoted most of their career to working on these issues. So I'm going to introduce them very briefly because their CVs are long and distinguished, so I'll just do it by title. We have Bertrand Ross, who's the Chancellor's Professor of Law at Berkeley, Ellen Katz, who's the Robert Egler Chair at University of Michigan, Pranita Tolson, who is the Vice Dean of Academic Affairs at USC, and Kent Greenfield, who is the Dean's Distinguished Scholar at Boston College. They are an extraordinary group of people. We're going to hear from each of them for a few minutes talking about what they see as some of the most important issues on the horizon. Then I'll ask a few questions and then invite the audience to take part. So with that, we'll start with Professor Ross.
Thank you, Dean Gerken, and thank you all for being here with us today, and thanks to my co-panelists for allowing me to participate on this panel with all of you. So we're getting close to the new round of redistricting in 2022. And although the 2020 election gave Democrats control of the White House and 2 houses of Congress, Republicans maintain control of most state legislatures responsible for drawing congressional and state legislative district lines. This round of redistricting will be the first one after the Supreme Court's decision in Rucho v. Common Cause, which declared partisan gerrymandering to be non-justiciable. Now, what I want to argue in my brief opening remarks is that partisan gerrymandering is not only a threat to fair partisan representation in the political process, it is now a threat to the multiracial democratic project.
To understand the threat to the multiracial democratic project, we need to return to the early 1990s racial gerrymandering case of Shaw v. Reno. In that case, the Supreme Court properly diagnosed a potential districting threat to America's multiracial democratic project, but identified the wrong source of that threat. It is only now that we can start to attribute the districting threat to the multiracial democratic project to the right source. In Shaw v. Reno, decided in 1993, the court addressed a challenge by white voters to the state legislature's use of race to draw majority-minority districts to provide racial minorities with the opportunity to elect candidates of their choice. North Carolina did not draw these majority-minority districts on its own. Rather, it did so in response to the United States Department of Justice's enforcement of Section 5 of the Voting Rights Act. That act, as enforced in the early 1990s, required that covered states, mostly states in the South, provide racial minorities with an equal opportunity to elect candidates of their choice. This meant drawing a proportionate number of majority-minority districts. The white challengers pointed to the unusual shape of the districts and the Department of Justice's demand that North Carolina draw these districts as support for their claim that the district line drawing violated the Equal Protection Clause. Core to the challenge was the claim that the government impermissibly considered race in the drawing of the majority-minority districts, and the court ultimately agreed. Focusing on the shape of one of the districts, the court explained, in some exceptional cases, a reapportionment plan may be so highly irregular that on its face, it rationally cannot be understood as anything other than an effort to segregate voters on the basis of race. As support for its conclusion, the court in Shaw diagnosed 4 race-based democratic harms that it said arose from the consideration of race in the drawing of district lines. Here I want to focus on the last and what I consider the most important of the harms. The court announced, when a district obviously is created to effectuate the perceived common interests of one racial group, elected officials are more likely to believe that their primary obligation is to represent only the members of that group rather than their constituency as a whole. I label this harm the racial representation neglect harm. This, the court concluded, is altogether antithetical to our system of representative democracy. Now, as applied to a state's drawing of majority-minority districts, there are 3 problems associated with this account of the harm. First, it just lacks empirical support. Although there is evidence suggesting that minority representatives from majority-minority districts do better represent racial minority interests than their white counterparts, there is no evidence suggesting that minority representatives neglect their white constituents. In fact, and this goes to the second problem with this account of the harm, it would be entirely irrational for minority representatives to neglect white voters in their representation. Legislators are part of a multi-member body that makes decisions according to majority or supermajority voting rules. As a result, in order for minority representatives to advance their policy goals, they necessarily have to build coalition with members of the white legislative majority. Recognizing this, it would be entirely irrational for minority legislators to neglect the interests of their white constituents, as this would impede their ability to build the necessary cross-racial coalitions to advance their policy goals. Furthermore, and a third problem, due to the racial wealth gap, minority candidates and representatives for office are reliant on white campaign contributors and spenders. They therefore literally cannot afford to have a reputation of neglecting the interests of white constituents. The multiracial democratic harm from the consideration of race to draw majority-minority districts are therefore imaginary at best. And the benefits from the state's consideration of race in the drawing of district lines, which includes increasing minority representation and voice in the political process, seems to far outweigh these imaginary harms. The court in Shaw v. Reno, however, did diagnose a real threat from the consideration of race in the drawing of district lines. It just identified the wrong source. And the right source for this harm diagnosis is now coming into view. That source arises from Republicans' use of race to pack minority voters and draw the maximum number of majority white districts to advance partisan gerrymandering. To understand why this source produces the racial representation harm identified in Shaw, it's necessary to provide just a little bit of background. For a while now, the Republican Party has been mostly a white party. In 2018, the Pew Research Center found that 83% of Republican voters were white as compared to 60% of the US population. In Congress, 91.4% of Republicans in the House of Representatives and 94% of senators are white. In districts where at least 3/4 of residents were non-Hispanic white, 82% elected a Republican representative in 2018. In contrast, 83% of the nation's most diverse districts elected a Democrat into the House of Representatives. Since the realignment of the parties in the 1960s, the Republican Party has always been the party that appeals more to white voters. But the whiteness of the Republican Party may have different consequences for districting in the coming redistricting cycle due to the rise of white identity politics. In a recently published book titled White Identity Politics, Ashley Jardina finds an increasing embrace of a racialized political identity among white Americans. Whereas the race of white people has historically been treated as invisible, it has become much more visible in the present. This white racial solidarity is not principally grounded in white supremacy and outgroup prejudice, although that is part of the story for parts of the white population. Instead, the primary motivation Jardina finds behind white racial solidarity is a concern among some whites about their in-group and a desire to protect white racial status in a demographically changing country. The rise of white identity politics is important because the majority of the Congress members in the House of Representatives in 2010, 2012, and 2014 were Republicans from majority white districts. And what is concerning about this racial partisan dynamic from the perspective of the American multiracial democratic project is that in an era of white identity politics, it is becoming rational for white Republicans to focus exclusively on advancing white interests at the expense of their minority constituents. Republicans from majority white districts simply do not need to participate in cross-racial legislative coalitions to advance their policy goals, and they can rely exclusively on their white donor class to be financially viable in elections. So what this all means is that in the short term, at least, there are rational electoral incentives for white Republican representatives from majority white and partisan gerrymandered districts to stoke racial divisions and govern as a white man's party. So while much of the focus on partisan gerrymandering has been on how it undermines the fair representation of parties and legislative bodies, we should not ignore the more ominous threat that it poses. And this threat has two related components. The first is a recent activation and encouragement of white racial identity and solidarity by Republicans who stand to benefit politically as a result of racialized partisan gerrymandering. And second, the promotion of racial white identity politics to create and reinforce perceptions that minority democratic gains are a threat to white racial status. As a result of these two components, white identity voters will be inclined to support white representatives who seek to advance white interests at the expense of minorities. Putting this all together, the threat to the multiracial democratic project from growing white racial solidarity and racialized partisan gerrymandering starts to become clearer. Despite all of the criticism, the court in Shaw v. Reno actually proved quite prescient in diagnosing the harm from gerrymandering. The problem is that the court targeted the wrong source. And now that we have a sense of the right source of the threat to the multiracial democratic project, the question is whether Congress or the court will do anything about it. Congress can do something about it by establishing independent redistricting commissions responsible for drawing congressional districts in every state. That would provide critical legal protections for the multiracial democratic project. And if Congress fails, the courts can step in to police the sources of racial representation neglect that are likely to be associated with Republican partisan gerrymandering over the next decade. Thanks so much.
Thank you so much. And now, we have Professor Katz.
So hello. Sorry, let me just come on in. It's so nice to be here, and thank you to Kelly and to Heather, to LSAC, AALS for convening this event. It's really wonderful to be part of this panel, this symposium with so many dear old friends and colleagues, and I'm really looking forward to seeing all of you in person, I hope before too long. The thesis of my talk, my paper, is pretty straightforward, and it's as much about the right to vote and sort of placed on this panel in that spirit, that much of the 2020 election litigation, and particularly the cases involving the rules for the casting and counting of absentee ballots, rested on a decidedly narrow conception of the right to vote. And this narrow conception confirms what I'll argue is the completion of an evolutionary process that began, and we can discuss the date, 13 years ago, 20 years ago, a series of cases that methodically circumscribed the right to vote, supplanting an older version with a new, very narrow version of what voting is. And I'm going to describe this contrast by borrowing from equality law and presenting this idea that what we are currently experiencing and what's the product of this evolution is a formal right to vote, a bare legal right to participate, that has supplanted an earlier, far more robust vision, what I'll call a substantive vision of the right to vote, that rested on the meaningful ability to cast a ballot on equal terms with other voters. That present law, that federal courts in particular endorse this formal conception It explains why they were so unmoved and wholly unpersuaded by allegations during the last election cycle of from dissenting justices, from the media, from the public, from academics about disenfranchisement. So long as the formal right to vote remained, the view was there was no disenfranchisement, even if voters were denied what I would describe as this substantive right to vote. So I'll sort of develop this point briefly by bringing you back to 13 months ago, give or take, in a photograph that you may remember seeing. And it was this was the Wisconsin primary held on April 7th, 2020. And it was a photograph of a woman named Jennifer Taft. And you may remember seeing it. It was cold in Wisconsin that day, and she's wearing a sweatshirt and a hood and a vest, and she's a mask, which at the time still looked quite unfamiliar to many of us. And she's holding a sign made out of a cardboard box in which she's written, "This is ridiculous." And her sign referenced a Supreme Court order that was handed down a few hours earlier that tossed out a federal court, lower court ruling that would have given voters in Wisconsin more time to cast absentee ballots. The voters who had requested those ballots had not received them due to a backlog. And instead, voters like Taft had to brave the polls or decide not to vote. And she told a reporter when the photograph was taken, "I'm disgusted. I requested an absentee ballot almost 3 weeks ago and never got it. I have a father dying from lung disease and I have to risk my life and his just to exercise my right to vote." And Taft's outrage was widely shared by other voters in Wisconsin, by the media, by commentators. And the Wisconsin primary itself was described as a fiasco, a tragedy, a debacle. And much of the blame, a lot of parties were responsible. Many targeted the Wisconsin legislature, which could have postponed the election or run it entirely by mail. There was criticism of the Wisconsin Supreme Court, which set aside the governor's order to delay or to run the election by mail. But a lot of the ire was directed at the Supreme Court as being distinctly culpable for throwing out this district court order that would have revised the deadline for processing absentee ballots. And in so doing, the Supreme Court forced voters like Taft to make this, what seemed to many of us to be an untenable choice, to risk their physical safety or decline to vote. And one of the things that I think is so interesting about the opinion was the court's vehement denial that it was at all responsible for any of the difficulties voters like Taft were facing. It's an unsigned per curiam, insisting that it's a narrow technical ruling. The district court intervened where it should not have, and the Supreme Court was simply fixing that error. And along the way, the per curiam repeatedly notes that we're not assessing the wisdom of what Wisconsin's up to here. We're not saying that modifications shouldn't be made to election procedures in light of this emerging global pandemic. And the court says, we can't stress it enough that whatever's happening in Wisconsin, however unfortunate it might be, it's not something, it's something Wisconsin officials can fix. It's not something that the federal courts are there to fix. And I bring up this small rushed per curiam to frame my remarks because I think it captured what were salient features of many of the federal court orders that followed. There's a lot of litigation, as you all well know, in connection with the election. Leading up to it, I'm going to put to one side the post-election litigation for present purposes. And in the course of that litigation, much of it, not exclusively, but much of it was about the rules for casting absentee ballots. Who's eligible to cast them, how they should be cast, what type of assistance folks should get in casting them, and specifically how they should be counted, which was an issue that gained traction as the general election got closer and there was concerns about whether this was going to all come down to one state and possibly to ballots received after Election Day. And in the course of all of this litigation, federal courts threw out most of the challenges. And specifically to changes that were made to electoral rules in response to the pandemic, when those changes were made by a federal court at a moment that was the lower federal court too close or perceived to be too close to Election Day, the so-called Purcell Doctrine, and the other line of cases that we saw in the general by a federal court or by some state actor, and under some views, even a state Supreme Court, that were thought to usurp the power of the state legislature under Article 2 of the Constitution, the so-called Bush versus Gore concurrence issue, and a variation of which we've seen in connection with challenges to independent redistricting commissions under Article 1. The notion that the Article 2, for the Article 2 purposes, that the legislature decides how the electors should be selected. And what links all of these cases and what I'm focusing on in my paper and what I think is worth our attention is a larger point. That whether these decisions are saying we're too close to the election day, whether these decisions are saying we're infringing or possibly infringing with the power of the legislature, underlying all of them is a substantive judgment. And it's one that was obscured in many of the cases, but came to be explicit in the fall in a decision in an opinion Justice Kavanaugh wrote when the Wisconsin case, a variation of the Wisconsin case, came up again. And namely that it's constitutional to run these elections under the procedures unmodified without the changes that were put into place. Namely that it's constitutional to force a voter like Jennifer Taft and Wisconsin voters generally to make this choice between risking their safety or not voting at all. That it's constitutional to refuse to count ballots cast after election day, cast before election day, received after election day, but postmarked before. That there's discretion in states within the state to decide what rules they're going to put in place. And to highlight the point, I guess I'll make what might seem like a far-fetched example, but just to drive it home. If a few days before an election, a state legislature were to say, only men get to vote, only people over 30 get to vote, there's no doubt that a federal court would come right in and say that's unconstitutional, and would say that regardless of how close to the election it is, regardless of the constraints of Article 2. And so too here, there's an implicit constitutional ruling in all of these cases. The Wisconsin case itself rested on a district court ruling, or the primary case, that that not extending the date, that allowing Wisconsin to run the election under unchanged rules, presented an unconstitutional burden on the right to vote under the Anderson verdict balancing test. The lower court was explicit and the Supreme Court displaced that ruling. Along the way, we get dissenting votes, Justice Ginsburg in the spring, Justice Kagan in the fall, calling the rulings of the Supreme Court and other federal courts disenfranchisement. Justice Ginsburg called it massive disenfranchisement. Justice Kagan pointed out that the rulings would disenfranchise citizens by denying them their constitutional right to vote. And what the Supreme Court says, and other federal courts said as well in this litigation, was you're simply wrong about that. That your rhetoric is wrong, as the court said in the RNC versus DNC, entirely misplaced. No one's being disenfranchised. And what we're seeing in these cases is the majority of the court parting company with the dissenters on the and holding what are essentially fundamentally different conceptions of the right to vote. And I think much of the public has shares that divide as to what the vote involves. I think the per curiam in that earlier case and throughout the election season genuinely thought it was issuing a limited technical decision because the law has evolved so dramatically. And we have seen this predictable culmination, if you will, of a dozen or more years of decisions that have circumscribed the right to vote so dramatically. And that we see in the last election cycle, sort of a culmination of this new paradigm. And I'll press this issue and I'll try and close here. We can talk if anyone's interested or when I finish the paper about the specific cases in which we see this, this formal conception of the right to vote emerging. A conception in which having the bare legal ability to cast a ballot, no matter how difficult, no matter how fraught that process is, suffices for purposes of the Constitution, and everything else falls into this realm of discretion. And there was, and it's worth recalling, an earlier version that's found in a series of decisions that's found voiced by Congress when it extends the Voting Rights Act and the like, that envisioned or conceived of the right to vote as not just an abstract formal right to cast a ballot that's counted, but the actual ability to do so through procedures that treat voters equally, that it's functional and that was functional in orientation and sensitive to the burdens that might present unequally across different populations. I see I'm past my time, so I will stop there, and thank you again for being here, and thank you for including me in this.
Thanks so much. Professor Tolson.
Thank you, Heather. And also thanks to Kelly and AALS and LSAC for organizing this conference. It's really an honor to be here and on a panel with such terrific scholars. So my comments, I want to use the January 6th insurrection as a jumping off point for thinking through some of these issues of race and democracy. Shortly before the January 6th attack on the Capitol, President Trump gave a rousing speech to the crowd, right? He called them amazing patriots. He said that they must, quote, demand that Congress do the right thing and only count the electors who have been lawfully slated, end quote. Our country, he told them, quote, has been under siege for a long time, and you'll never take back our country with weakness. You have to show strength and you have to be strong, end quote. While it remains to be seen whether President Trump's words that day rise to the level of criminal incitement, it is beyond dispute that by casting doubt on the outcome of the election months before it occurred, he emboldened his supporters to take up arms to prevent Congress from certifying Joe Biden's clear victory. And by wrapping his lies in the cloak of patriotism, Trump fueled the view that a violent assault on the Capitol, which resulted in 5 people dead, was a legitimate action, similar to the actions of the American founders in 1776. In fact, the mob seemed to believe that the insurrection was their 1776 moment. Many returned home after the attack, expecting celebration of their actions rather than condemnation. Besides being a horrible bookend on the Trump presidency, the storming of the Capitol illustrates how the language of patriotism and revolution has been co-opted to excuse behavior that could be described as inciting an insurrection, or more pointedly, as a seditious attempt to undermine the peaceful transfer of power. Not coincidentally, the language of revolution reemerges when whites feel threatened by the rise of minority political power. For 7 weeks, the Trump campaign filed lawsuits in multiple states key to Joe Biden's victory, seeking to disenfranchise minority voters in urban centers like Philadelphia, Milwaukee, Atlanta, and Detroit based on specious claims of fraud. The Trump litigation and actions by some local officials on the ground called into question the legitimacy of the election and really a government in which voters of color play a central role. Resisting a free and fair election is not and never will be patriotic or revolutionary. But the efforts to overturn the 2020 election highlights the extent to which our commitment to democratic ideals, even in the face of a free and fair election, is highly racialized. No matter how much we commit to democracy as an ideal, there will always be some subset of white people who think that they have to, quote, take the country back when their preferences do not carry the day within the democratic system. In other words, democracy for me, but not for thee. Importantly, our commitment to democracy has always been racialized. No matter how much our rhetoric about being a democratic ideal for the world to follow will convince you otherwise, we forget that it is our love-hate relationship with democracy, rather than an absolute commitment to democratic ideals that is as American as apple pie. The insurrectionists hold out 1776 as an ideal for a reason. The revolution was a time in which colonists broke away from a foreign power and planted the seeds of the greatest democracy on earth. But an uprising in the French colony of Saint-Domingue, 15 years after the American Revolution, tested our commitment to democracy in a way that the French Revolution, which also occurred around the same time, did not. Unlike France, Saint-Domingue's revolution, which we now know as the Haitian Revolution, initially started out as a slave rebellion. Nonetheless, it shared the same common theme with the American Revolution that resonated with many in the founding generation: the desire to break away from a foreign power and establish a sovereign nation. In fact, prominent Federalists like Alexander Hamilton and Timothy Pickering saw these parallels and supported the rebellion throughout many of its iterations, with the forces of the rebellion's leader, Toussaint Louverture, battling France, Britain, and Spain at various points, all of which sought to gain or regain control of the colony. When the treasonous Benedict Arnold escaped across enemy lines during the Revolutionary War, the fact that he and other British troops were ejected from Guadeloupe by former slaves during the Revolution likely induced many smiles among the ranks of the Federalists. But support also came from official quarters. For example, President John Adams appointed Edward Stevens as Consul General to build diplomatic relations with Saint-Domingue. Unsurprisingly, Thomas Jefferson was not a fan of the uprising because slaves there overthrew a plantation system similar to that which had formed the backbone of the American South. In a letter to the Revolutionary War hero Marquis de Lafayette, then Secretary of State Jefferson voiced support for the French Revolution while warning that the French colonies, quote, will be lost if not more effectively secured. Indeed, no future efforts you can make will ever be able to reduce the Blacks, end quote. Jefferson worried more generally that the insurrection in the Caribbean, quote, has given a considerable impulse to the minds of the slaves in different parts of the US and could lead to violence on America's shores. Jefferson was not alone in this belief. In the early days of the Haitian Revolution, Southerners worried that the flame of sedition would spread northward. Jefferson and other slave owners were well aware of how the dramatic increase in the slave trade created the conditions ripe for revolution in the States. Enslaved Blacks in Saint Domingue well outnumbered the whites on the island, which had also been true in South Carolina in 1780s. Other Southern states also had significant numbers of slaves, sometimes making up over 30% of their populations and generating similar fears of insurrection. In 1802, Napoleon Bonaparte, with support from both the Jefferson administration and Great Britain, sent troops to Saint Domingue in an effort to retake the colony and reestablish slavery, even though the practice had been outlawed throughout the French colonies in 1794. While officially following a policy of neutrality, Jefferson imposed Toussaint Louverture's regime and curbed the trade with Saint Domingue that had thrived during the Adams administration. However, his refusal to send resources and aid undermined French efforts to retake the island. While the French were able to capture Toussaint Louverture, their invasion failed and the island was renamed the Republic of Haiti in 1804. The new Haitian constitution not only extended citizenship to all on its shores, but also, importantly, permanently outlawed slavery. As a Southerner and a slave owner, Jefferson's opposition to the Republic of Haiti, a majority Black nation of former slaves who wrestled control from white planters and rebuffed foreign superpowers, his opposition is not surprising, but it is a position that is hard to coherently defend given the mystique and reverence around the right of revolution and the clear parallels between the Haitian Revolution and our own. The formerly enslaved in Saint Domingue exercised the right of revolution, just as the Americans and the French during their revolutions, to establish a community that will recognize and sanction their freedom. The prevailing sentiment among many in antebellum America that enslaved Blacks could not be a political community because they were not independent, nor the holders of rights, well, that was inapplicable here. The people in the new Republic of Haiti, including the formerly enslaved, free Black and mulatto or mixed communities, had cleared this bar time and time again, beating back armies from 3 different sovereign nations seeking to curb this freedom. It is clear that the problem for Jefferson and others was the emergence of a free Black state, which not only threatened to disrupt the plantation system in the American South, but also threatened the notions of white supremacy that were so key in maintaining that system. Haiti is a clear historical example of our tenuous relationship with democracy, of the fact that many Americans, like Thomas Jefferson before them, conceive of democracy as desirable when it produces outcomes preferred by white people. There's no amount of law, no level of transparency about our elections, no degree of freedom and fairness in our elections that can save us if enough people start to believe that our commitment to democracy can waver when Black and brown people exercise power in ways that are outcome determinative. So when we wondered why the Capitol was so poorly manned, despite the advance notice that there will be a huge rally on the 6th that could possibly turn violent, when we think about the fact that the insurrectionists were able to return home after storming the Capitol, when we consider that only hundreds have been arrested, even though thousands were present, while we sit with the fact that there have been no congressional hearings on this insurrection, while we marinate on the fact that elected officials still, after everything that happened, promote the conspiracy that the election was stolen, it is all an unfortunate reminder that for people of color in this country in particular, our democratic ideals have always been provisional rather than permanent. Thank you.
Thanks, Renita. Professor Greenfield.
Thank you. It's such an honor to be on this panel of such distinguished scholars doing such important work. I'm going to talk some about the connection between voting rights and corporations. And then you'd be forgiven to think that these 2 areas of the law have nothing to do with each other. But I think with the recent events have proven that they do have some relationship. Now, let me start by talking about the fact that in America in these days, voting rights and electoral power depend on money, as well as a ballot box. And this is a function of constitutional doctrine. Ever since Buckley v. Vallejo from over 45 years ago, and to a lesser extent Citizens United, we know that the support from a rich person means more than a support from a poor person, because the rich person's support comes with money. And the current efforts to restrict voting rights across the country have to be seen in the context where in which that the electoral process that we have depends so much on money, because these current efforts to restrict voting rights, which disproportionately affect people of color, must be understood in a context in which the existing way we finance elections already put people of color at a disadvantage, as Professor Ross mentioned a few moments ago. In a political system that prioritizes and constitutionally protects money, this money disparity and this racial wealth gap will beget and cement political disparity. And this political disparity creates regulatory advantages for the moneyed classes, allowing them to build their wealth. As Dorothy Brown's excellent new book, The Whiteness of Wealth, so reminds us that this is the wealth cycle and the regulatory cycle built on each other. Now, what we've seen over the last couple of months, ironically, is that voting rights advocates have been using politicians' dependence on money as a pressure point against those voting rights restrictions. And they've been marshaling the fact that corporations do not want to be identified with as supportive of these restrictions. Now, and the reason why corporations have become the target of so much pressure, in part, is because there's not many other options. As we all know, restrictions on voting rights, by definition, do not have an easy political remedy. And judicial remedies these days depend on a judiciary, and particularly a Supreme Court, that seem to be disinterested in constitutionalizing the problems or seeing the problems as constitutional in nature. So, but money still matters in politics. And so in an ironic way, perhaps, drawing on corporations to support voting rights in Georgia and elsewhere makes total sense. They have leverage in the debate that the people hurt by these voting rights restrictions do not. Now, this is especially true in Georgia, because Georgia is one of the 29 states that allows corporations to contribute directly to candidates, something that's not true under federal law. Florida, too, by the way, allows corporations to donate directly to candidates. And one of the reasons why Coca-Cola and Delta Airlines were under such pressure recently is because both of those companies had directly contributed to Brian Kemp, the governor of Georgia, and to the Georgia legislator that was pushing the voting rights restrictions through the Georgia legislature. And because of this pressure, the corporations have responded, culminating in a big two-page ad or full-page ad in the New York Times in April, signed by 100 corporations and other individual corporate leaders, including Google, Amazon, General Motors, all decrying the efforts to restrict voting rights. Now, it's a sorry state of affairs that we find ourselves in America, that the mechanism to put pressure on politicians is corporate speech and money, but here we are. Now, what do we make of that? If that's diagnosis, what's the prognosis? What do we make of this? Now, the GOP has definitely pushed back, right? We've heard recently from Mitch McConnell, who has said that corporations should stay out of politics, which is sweet coming from him. He raised over $70 million in his most recent campaign, much of which from corporate, either corporate PACs or corporations themselves. Ted Cruz recently had an op-ed in the Wall Street Journal saying that he would no longer take corporate money, corporate PAC money. He's saying the silent part out loud. Usually a politician saying, I'm not going to take your money anymore, is not seen as punishment to the corporations, but it's only punishment to the corporations if the corporations are getting value for their money and contributions. So Ted Cruz sort of made that obvious. My colleague here at BC, Heather Cox Richardson, has said that she thinks that this is a significant break from the past, in which the implicit deal for several decades now is that the GOP's the implicit deal within the GOP was that the anti-regulatory efforts and the electoral efforts would be financed from corporate coffers and but operationalized at the polling place with social conservatives, motivated with anti-government, anti-regulation, pro-religion, and rhetoric and racial dog whistles. Now, the problem, according to Richardson, is that Trump has said the racist part out loud, and it's more and more difficult for corporations to be seen, to be aligned with that. And perhaps ironically, corporations are more savvy about this than the public servants themselves. Corporations are more sensitive and attentive to the richness and the diversity of America than many politicians. Corporations have to look at the long term. They have to. They can't be explicitly xenophobic. And in fact, as the GOP pushes further to restrict voting rights, the separation between mainstream corporate America and the GOP will become more attenuated. In a world in which the GOP is de-diversifying, it separates them more from American business, which has to be much more attentive and sensitive to the diversity of America. So how do we build on this trend? Now, one thing that I think it's fair to say is that, I don't want to be sanguine about the interests of corporations. Corporations are certainly not acting altruistically; they're acting out of self-interest. But I do think that this is a trend that we can further, that we can nurture, in part by taking advantage of the market-based nature of corporations. The market, as we've known for a century, is a function of law, and and law has a hand in delineating the focus and obligations of corporations. Now, under current constitutional doctrine, wealth is translated into power in voting and elections. Under current corporate law doctrine, this power can be marshaled by corporations for the benefit of shareholders, mostly the financial and economic elite. But that's a product of law. I don't think Buckley or Citizens United are going anywhere anytime soon, but I do think we could adjust corporate law doctrine to force corporations by adjusting fiduciary duty norms, by changing the decision-making structure, who's on the corporate board, to make corporations much more robust, much more diverse, much more pluralistic. So perhaps in an ironic way, one way to further democracy in America today is to make corporations more democratic. I'll stop there.
Thanks. Well, I will say, given that the theme of this conference is supposed to be shoring up the rule of law and democracy, this is a grim set of prognoses. So I'm going to try to pull the work together because you all actually are touching on a lot of similar themes. And I wonder if I just might start with just a general question for the panel that pulls from Ellen's observation about formalism and functional forms of power. Because I think that's, if there's a through line here, is what connects everything that you're describing. And so here's my first question really is to think a little bit as a group about how do we deal with that problem if we've traditionally looked to the rule of law to defend democracy. So just to put a pin in it, and Bertrand, you were describing the ways in which the sort of new forms of white supremacy are taking place. We used to call things like that racial polarization, which had a sort of anodyne way of describing a set of institutional relationships that involve racially based voting. But it's not something the court's particularly good at recognizing or thinking about. And regardless of whether Congress passes something, it eventually is going to get to the court because of its duties to evaluate whether Congress has exceeded its power. And so I just want to ask you all, do you have any hope at all? I mean, Ken has just told us we should look to corporations, not courts, as at least a partial sort of hope for some democratic support. I'm just curious where you find, if you were sort of spending your philanthropic dollars, your time, where would you put your energies if we want to push forward? So maybe I'll start with Bertrand, but then open it up to everybody.
Yeah, thanks, Heather. And I apologize that the panel is kind of filled with such pessimism about perhaps the role of law. And I am quite pessimistic about the role of law, though I threw in those two little nuggets about what, Congress and how the court might be able to intervene. But I think realistically speaking, it will ultimately come, and the change will come, or the limits to the damage will come from the people themselves. And I do think that one of the things that I'm feeling cautiously optimistic about is the fact that we saw an extraordinarily jump in turnout this past election, and we saw a extraordinary diverse array of voters participating in this election. In Georgia being the prime example of this shift in terms of the demographic of those who are voting, both in the general election in November and in the turnoff and then the runoff election in January. And so what are the factors that are at play here? Well, it seems that there's a recognition by campaigns that the best means by which you secure votes and support is to actually engage with people on the ground, right? And so engaging in greater canvassing and mobilization efforts. But that, with respect to those infrequent and non-voters, that canvassing mobilization effort will require a level of engagement that is quite intense and requires that politicians and campaigns, in a sense, provide a sense of how they're serving the interests of those constituents that they are seeking to vote. Now, to the extent that these politicians are focusing on, white racial politics or racialized forms of politics, that could be quite damaging. We saw that both in campaigns in the past that were associated with former President Trump. But I think that there can be an important counter effects that groups can play both inside campaigns and outside campaigns with respect to bringing and engaging in a more racially inclusive message with respect to understanding our democracy today and what it could be tomorrow, to diminish that sense of threat associated with multiracialism that some members of the population may feel and experience, and try to bridge those partisan lines enough so that we are not divided on things that are existential to this country. And so that is kind of my ray of hope. And the fact that the amount of money in politics is for the most part quite damaging, but here's the silver lining: that amount of money in politics allows for a degree of engagement on the ground that we might not see if there weren't this flow of money into the campaigning. And so I think that is a mechanism. I don't have much hope that courts can intervene in a way that's particularly productive, or that this court will do so, but I think that things can happen outside of the legal processes in ways that can be productive for our democracy.
Fidina, what if I could turn to you? Your work has always been in conversation with the past and the present and our history and the law. And I wonder how you're thinking about this moment right now.
Believe it or not, Heather, I am incredibly hopeful. I know that my comments suggest otherwise, but this is why I try to use a historical lens, in part because it shows that we've been here before. And in some ways, we've been worse off than we are now, right? I mean, the period following Reconstruction was a really dark period in our country's history, but we were able to get past it. It took a long time, but in part, we were able to get past it because of sacrifices made by everyday people to fight back. And, eventually in conjunction with legislative action in the courts, we were able to make significant progress on having more racial equality in voting. And so the history really does encourage me to keep my eyes on the prize. And I do think that there are efforts now to try to protect our democracy. So HR 1 and HR 4, which was the subject, HR 1 was the subject of the last panel, although HR 4 did come up. I do believe that Congress has significant authority to address some of the problems that we are having with our democracy now. Congress can't be the only solution. Just like legislation that focuses exclusively on race cannot be the only solution. I do think we have to have this partnership between a lot of the sort of race neutral measures you see in HR 1 in conjunction with a new coverage formula under HR 4. I think that'll move the ball forward significantly. But the reality, though, is that we are in conversation. We are still talking about ways to improve our democracy post 2020 election. There are still scholars doing good work around this, and there are still movements on the ground to try to increase awareness of these issues. So I am incredibly hopeful. But I do think understanding the past is a way of really trying
Oops, I think we lost Renita for a second, unless I'm the one who's lost here. No, I see everyone else moving. Okay. We just lost you for a second. You said you were just finishing up your remarks. You're saying about moving forward.
Yeah, so understanding the past is very important to prevent it from replicating or repeating itself. So yeah, I'm hopeful.
So Ellen, can I ask you a question? Because whenever I think about being on the lawyering chessboard, you're always the person who sort of is seen for often so far down the line. I wonder how you think about what happens when either HR1 or HR4 or some of the solutions that are on the table hit the courts. What would you predict? What's their best defense? How would you frame that legislation?
So thanks. I guess in part I'll just agree with what both Bertrand and Renita have said. I think looking ahead is a multi-party, actor institutional focus to think beyond federal courts in terms of making progress. And so some of that's going to be voter mobilization and turnout. And as Renita's pointed out in her work consistently for a long time now, I think, and this goes to your question, the elections clause is a very promising way for Congress to move forward. And there's a lot Congress can do pursuant to that could protect lots. And you can't predict everything, but could make a lot of headway in countering some of the things we've seen state legislatures doing just in recent days even. You know very well the difficulties and the constitutional challenges that will be coming HR4 and beyond to the extent if congressional legislation comes and to the extent it reaches beyond federal elections to state procedures. We know what that looks like. And I don't, I'm less optimistic than Renita on that coming out in a good way. I guess I would add, and this is more of a dodge of the question, I suppose, than rather than writing the opinion, I can envision striking down some of that legislation. There are other actors too, and I'll just put into the discussion things we've done in Michigan here. In 2018, we amended the Constitution, our state constitution under Prop 3, adding absentee voting on demand, sort of very basic things, early voting, automatic voter registration, and procedures that passed with lots of support from the voters, and I believe made it easier for voters to cast ballots under very difficult circumstances in the last election. So I think there's a meaningful role for state law as well as part of this, as I am aware, not answering your question, but that there is. There are places mobilizing the voters, using the election clause, bringing in state law. We can't envision every problem that's going to come up, but we can do a lot better in shoring up some of the problematic areas.
Excellent. So I'm going to ask you a question that is from Kathleen Morris, the great Kathleen Morris, which is in some ways about corporate regulation as well, which is Facebook and social media. Is not something you were talking about in this iteration of it, and I realize I'm cold calling you, which is completely unfair, but to the extent that you think that that is also part of the democratic project, what work is there to be done on that side of the aisle?
Yeah, I do feel like a little cold called, but
sorry about that.
It's fine. Well, maybe I'll back up and sort of talk, sort of take the meta question, which is, that each of us as citizens and as human beings are as affected by the decisions of Facebook's oversight board as by the FEC, right? And so the interaction between the regulation world, the regulatory oversight of those big mega corporations, and our daily lives. I mean, that's a key area should be a key area of attention here. And I don't really know. I know some people are saying that these big organizations become sort of quasi state actors if they get so big, and I'm unsure about what I think about that. I do think though that having these kinds of bipartisan boards, oversight boards, is probably a good thing. But I do want to go back, Heather, if I can, and answer your first question, which is, what are some things we can do. And I do think that given the restrictions on voting rights that we're seeing, having embedded in them their own immunity from political attack, we have to come up with some other way to put pressure on. And that's why I think these recent efforts to use corporations as a pressure point is fascinating to me. And I think because, especially for corporations that are public facing, that are consumer facing, they've got to be much more attentive to the American polity than a lot of politicians, for the reasons that my colleagues have set out. And I think increasingly corporate money is either sitting out or turning blue in some important respects. I just was looking at the Open Secrets numbers from 2020. That the top spending publicly traded corporation was Chevron. It spent about $6 million across all races in 2020. There were 13 unions that spent more than that. So oddly enough, Citizens United may have had, because it uncapped both union and corporate spending, may have had sort of a bluish effect over the last decade than a reddish effect, contrary to what many people thought at the time.
So I want to just maybe go back to a question that Bertrand began with. So for those who don't do election law, there's always sort of been this traditional divide between direct access to the ballot, the kinds of things that Ellen was talking about, and then partisan gerrymandering, where everyone can vote, but it's simply that, but the way that the districts are designed have real effects on power. And Bertrand gives us this, sort of evocative way of thinking about this puzzle that we've always had between partisanship and race. It often used to be the kind of tale we would tell is that partisan claims got pushed into racial claims, and there were these strange alliances among parties because of the ways in which the Voting Rights Act was so much more robust than partisan gerrymandering protections, that's the hydraulics of it. I wonder what you all expect from the redistricting cycle that's coming up. What do you expect to see? And do you expect the Voting Rights Act, Section 2 of the Voting Rights Act, the one part of it that still remains of the old girl, will have an effect on it? And I'll just remind everyone in the audience, please feel free to send questions into the chat. So Bertrand, do you want to kick us off for that one?
Sure. Yeah, I think that this will be a really interesting cycle. The court has officially, took its hands off of the pedal, or just decided to absent itself from policing partisan gerrymandering at all. And so any sort of court challenges will have to go and feature race, either through the 14th Amendment or Section 2 of the Voting Rights Act. Now, what I expect to see with this next round of redistricting is in those states in which the state legislature still control districting, which is fewer and fewer each decade, which is promising, is pretty extreme forms of gerrymandering. And I expect that effort that we saw in North Carolina, that was at the core of the Rucho case, in which, they're trying to draw 11 out of 13 Republican districts. And the only reason why they drew 10 is they couldn't imagine a way to draw an 11th. And I think that, they're going to imagine all ways in which they could rig the system for partisan advantage. But I think that what they'll do, and one of the main tools by which they'll do so is rely a lot on race, right? Because I think the Republican Party has very much associated itself with white identity. And as a result, it will focus in many states on capturing as many majority minority white districts as it can, or drawing as many majority minority white districts as it can to capture them, and to draw as few majority minority districts as they can. So the classic of packing phenomenon will come into play. Now, the question is, will they be subject to any sort of restraint on the racial side, right? We don't have Section 5 that enforced a soft mandate that states, at least covered states, draw a proportionate number of majority minority districts. Will Section 2 be enforced in a way that subjects states to some sort of constraint with respect to the number of districts that they draw? Because you can imagine some scenarios in which, a state has 10 to 15 districts and minority voters are packed into 1 or 2, right? And drawing districts in that particular way. And so I don't have much hope that the court is going to re-intervene and maybe revive its partisan gerrymandering policing that it's never really done. but I'm also skeptical about what it's going to do under Section 2, right? I think Section 2 is under some pressure right now, with the court having some skepticism of any legislation that has any sort of disparate impact type standard, even though Section 2 is not purely a disparate impact standard, but it might be close enough for the court to raise questions about it. And they'll focus on whether there's any sort of purpose or intent to discriminate or use race in these particular instances. And to the extent that the states can, or the Republicans can, rely on partisanship as their motivation, right? I think it might excuse them from any further interrogation from the courts. And so I fear that consequence, and I fear the result and how it might lead to a more extreme racialized form of politics over the next decade.
Ellen, I see you nodding. I'm curious what you think.
Well, I mean, I want to bring Fernita back in so I can channel her optimism, because I actually share Bertrand's pessimism on this one. I mean, this will be the first cycle that we're going through since the end of Section 5. The case law from the last decade on gerrymandering, racial gerrymandering cases, where we saw the deployment of claims the Voting Rights Act made us do it in, what one might characterize was quite a cynical fashion, giving way to not particularly productive results. So I don't see Section 2 being a real break on any of this. Guy Charles's work, I think, has explained this beautifully from the last decade on what's happened here. So I don't, and the ability to, I mean, and this is an old argument, claim partisanship rather than race as the motivating factor for the packing of minority voters into, fewer and fewer districts, I think insulates a lot of claims from the racial gerrymandering attack, either under the Constitution or under, a Section 2 type claim. So yeah, it's just unbridled pessimism there. And, we could compound that with the vulnerability of redistricting commissions, at least with regard to federal elections. We can all count votes with the precedent upholding that from six years ago, I guess now, 5-6 years ago. There's not, the justices that were part of that critical majority are not on the court anymore. So while we haven't heard from everyone, there's, an undeniable vulnerability of some of these institutions. It won't affect, I don't believe, their ability to affect state redistricting plans. So there's a ripple effect there, and maybe there's some optimism with regard to that. But if there's an expectation that the Voting Rights Act itself is going to provide a meaningful break on the excesses of either partisan gerrymandering or somehow increase minority representation, I'm looking at Fernita and hoping she can cheer me up, but I don't see that happening.
Fernita, what do you think?
I was thinking about a presentation that Ellen gave a few years ago when we were at Ohio State, and it was about Shelby County. And Ellen, she said, I attempted to take the opinion seriously, but it was really hard for me. And I never forgot that, especially looking at a lot of the case law over the last decade, that you have to try to take it seriously, even when you understand that really the court's goal is to try to remove any consideration of race and then make it a free-for-all when it comes to partisanship. And I think moving into the next decade, I do think that's why state law will become increasingly important in this area. So for that reason, I remain optimistic, right? Because state constitutions have free and fair election provisions. They have right to vote provisions that we can draw on. Josh Douglas has done some great work around this. And I also think that, litigants, with federal law, you have to be careful now in a way that maybe wasn't quite as true, but the writing has been on the wall for a while, right? Bertrand points out how with Section 2, it's under pressure. And so I think with Section 5 already gone, we have to look for different, AirPods, sorry. We have to look for different and more creative ways to try to protect minority interests in the next round of redistricting.
Ken, I want to ask you a question about the relation between race and partisanship in your domain, and then I want to turn to a Ned Foley question. But, in a funny way, this corporation is sort of elite politics at some level, but also sort of attentiveness to consumer, which is more of a groundswell. It's really hard to imagine corporations doing this if it were partisan, right? If explicitly the Republican Party, the Democratic Party is doing something. And yet, maybe a more positive sort of, maybe to be cheerful with Fernita, these racial questions have actually motivated them. The fact that there was so much racism behind much of what happened in the last few months of the elections process. I'm wondering just how you think about the relationship between those two things, given that the corporations do hold themselves out as nonpartisan, but are taking stances in a world where race and partisanship are just swirling together. Oh, and Kent, you're muted.
Sorry, I should know that by now. Yeah, such a fascinating phenomenon, right? Like, and I'm reminded a couple of things to sort of chop up here. First of all, this, in terms of having sort of popular pressure being borne on, aimed at corporations, it only works if the corporation is consumer facing, right? If you're Coca-Cola, it makes sense to threaten a boycott or threaten a protest. But if you're some company that's doing non-consumer, if you're Boeing, I mean, how are we supposed to boycott Boeing, the consumers? And so, there's only limited access points here. But my colleague Heather Cox Richardson, when she was saying that for so many decades there was this implicit deal that the corporate mainstream would sort of populate or fund the GOP, but you couldn't say the racist stuff out loud. And the reason why you had such a break between the corporate world and Trump was because he started saying the racist stuff out loud. Now, I guess my main point, if I were to sort of summarize anything, is that we should seize this moment and try to nurture that separation. And the GOP is sort of dooming itself by focusing on these voting rights, which will make their own politicians less and less open to the views of the diversity of America, the pluralism of America, and in a moment where corporations are becoming much more and more attuned, and I do think corporations are being more willing to be open and focus on the not being partisan, being welcoming and being open on race grounds. I'm reminded of Coca-Cola's commercial in the 2017 Super Bowl at halftime. Right after Trump came in, the Muslim ban was just on tap, and Coca-Cola's halftime commercial was "America the Beautiful," being sung in all these different languages with all kinds of different people and singing it and focusing on all kinds of different families. And I think that's the kind of thing that we could engender and nurture.
So Ned had a really lovely question. Ned Foley had a really lovely question connecting a conversation in an earlier panel. So for those who weren't there was sort of a sentiment within that panel that it was important to separate out questions of vote counting and the legitimacy of the election and so on from other kinds of elections questions. And Ned's astute question, which I really particularly goes to Franita's statements, but I suspect all of you have a view, was what is your view of that? Is that a mistake actually in terms of framing these issues? I'm letting you read the question. So I saw Bertrand. Oh. I'm gonna pop over to him first, and then I'll.
Sorry.
No.
Yeah, I mean, I don't separate them out insofar as we're seeing the targeting, as Ned mentions in his question, of minority urban centers that tend to have a high proportion of minority population. And what this harkens back to me is your earlier scholarship earlier on vote dilution, in the sense that when you diminish disparately confidence in election in certain places with a high number of minority voters, right, you in a sense can dilute their vote in this way. If you have this process that is more rigorous and scrutinizing of vote counting in certain places and not others, then that will almost inevitably often lead to certain voters being dismissed in certain places and not in other places. And if those votes get dismissed in certain places that tend to be higher proportion minority because those ballot counting processes are being scrutinized more closely than in other places that tend to be more white, that can have a harmful effect in terms of the value or the the quantity, the objective value of the vote in those places. And so also there's this other corresponding effect that I'm worried about too. To the extent that it becomes in our mind that there is Detroit, and we know in Detroit there are nefarious things that go on there, and we are more likely to be dismissive of the vote totals there, and we are often, we might be even sometimes tempted to take those vote totals out and think about how the election would look without Detroit. That has the effect of really diminishing the value and importance of the vote, and that can instill within the people of Detroit that our vote matters less, right? It may not count less in that election, but to the extent that we give a sense that their processes are inevitably corrupt, we give them the sense that, you know, we feel differently about your votes. And in the next election and future elections, that may diminish their willingness, Detroiters' willingness to vote and participate in elections. So that's what I worry about. And that's where I see them linked very much in important ways.
I agree. Oh, sorry, I didn't know.
Please go ahead. That's just going to.
I agree 100% with that. I think when you think about the harm, regardless if it's issues of access or aggregation or counting, the goal is to diminish the political power of minority community. And so it's really important to think about it, I think, cohesively. But I wonder if we have to take a different approach in terms of strategy. Because there are different lines of cases that govern the fundamental right to vote, separate and distinct from the right to vote free of racial discrimination, particularly in the court's case law. So I wonder if it's useful to think about them separately in order to avoid those areas of the court's case law that make it really difficult for plaintiffs to win these cases. And so you may get some purchase with that approach, but in terms of the harm, I agree that vote counting is something that we should think of as another dimension of this problem.
So Kent actually just popped himself into the queue and came up with a great question, which really goes for Nita to something that you were talking about early on. I know that Guy Charles has written extensively about it, which is about thinking about universal versions of voting rights and voting rights that are more targeted. This one is about regions. It's a federalism question in some senses, but do you think that Kent asked essentially what's understood to be the Manchin Compromise, which is applying a Section 5 to all states, would be constitutional?
I'm happy to jump in unless somebody else wants
to. Please go ahead. Perfect.
So I think it depends, right? So it is a federalism problem. And I actually think you made this point on the first panel about, sort of generalizing out preclearance could pose these federalism problems. And this is why HR 1 has some appeal. It's kind of the future of voting rights in this area because it's neutral and it doesn't have those same federalism problems because it applies to federal elections. But that being said, there are provisions in HR 4 that I think get around some of that. So there's a known practices provision that targets certain practices as opposed to certain geographic areas, where it is technically a pre-clearance sort of coverage formula for the entire United States, but it focuses on those practices that have been historically used to disenfranchise communities of color. So for example, when a state redistricts, they would have to get that pre-cleared. Voter ID laws, proof of citizenship requirements, when they refuse to circulate materials in certain languages, given that they have a large portion of minorities who speak that language for elections, ballots. These are practices that would have to be pre-clear, which I think avoids some of the problems you would have in having a coverage formula that applies nationwide. Instead, focus on the practices rather than the geographic entities.
Other views on the panel?
So I might just circle back, if I could, to combining, I guess, Ned's question a little bit as well. I think the recount question, not the recount question, the counting of ballots and the way that Detroit was targeted raises, sorry, this is not responsive to Kent's question, but I just want to add this. We haven't really used the tools that we have for conventional voting rights litigation, whether it's constitutional claims, whether it's right to vote claims, whether it's racial discrimination claims, and put that on what we might call the back end and sort of think about and sort of adding transparency and thinking about that process. What does a Section 2 claim look like if it were applied to the way a state is recounting is the wrong word, counting ballots and certifying the election? And we haven't really looked at that carefully. I think Bertrand's exactly right about the damage that is done at that juncture, and that we saw in this iteration more visibly than in my lifetime. I think that we've seen that happen, and it ties to what Freddie is just talking about too, in terms of how we understand whether it's the racial discrimination component, it's the right to vote component, and what it ends up looking like. Could Congress do something to help, which I guess is a little bit more responsive to the more recent question in terms of thinking about that? We do need an accounting and a looking to it. And I think one of the difficulties that we saw in Detroit in the days following the election, and many of my students reported this who were there, was the role of private individuals who were disrupting, who came in from other communities to disrupt the recount and to, lodge accusations of impropriety with very little foundation. That's not state action, and it's very difficult to understand how we deploy that. But it's certainly an area where I do think we need to sort of focus attention where we haven't previously done, because the last election shows a vulnerability, which gets back, I think, quite to many of the questions that were discussed this morning about voter confidence in the process. That post-election counting is obviously crucial to how we think about it and how we should deploy the tools that we have traditionally used for the casting of ballots, for voter ID, for districting and the like, to that process.
So I am sorry to say that we are right at 2:45. So I have to say, whether or not those in the audience are leaving here with pessimism about the future of voting rights and rule of law, I think you must have enormous optimism in a field that has such distinguished scholars inheriting the mantle of leadership. You all are amazing. It's so nice to be part of this conversation. It makes me miss my old job. So I just want to say thank you all for not just being on this panel, but for all the work that you've done that has brought you here. We're in your debt. Take care, everyone. Bye-bye.
Thank you.
good afternoon, good evening, or good morning, depending on where you are. It is my great pleasure to welcome you all to this final panel for this conference. I understand it's been going really well, and I'm only sorry that I haven't been able to attend all of the extraordinary panels at this AALS conference on rebuilding democracy and the rule of law. Of course, this session is focused on improving presidential elections going forward. So looking ahead, I think this is a crucial bookmark to this conversation. It's my job really to ensure that our incredible panelists have the appropriate amount of time to share their remarks with you. So I will offer brief, very brief introductions of each of the 5 panelists. They will speak for roughly 7 minutes and have an opportunity to engage with each other. And we will then also be taking questions from the attendees. So our first panelist is Joshua Douglas, who is the Ashland Inc. Spares Distinguished Research Professor of Law at the University of Kentucky. He is the author of Vote for US, Vote for Us, stated otherwise, How to Take Back Our Elections and Change the Future of Voting. He teaches and researches election law and voting rights, civil procedure, constitutional law, and judicial decision-making. Joshua's most recent legal scholarship focuses on the constitutional right to vote, with an emphasis on state constitutions, as well as the various laws, rules, and judicial decisions impacting election administration. He has also written extensively on election law procedure. Thereafter, we'll hear from Michael T. Morley. Professor Morley is a faculty member at Florida State University. He teaches and writes in the areas of election law, constitutional law, remedies, and the federal courts. Michael is best known for his work on election emergencies and post-election litigation, nationwide and other defendant-oriented injunctions, and the jurisdiction of the federal courts and their equitable powers more generally. He has testified before congressional committees, made presentations to election officials for the U.S. Election Assistance Commission, and participated in bipartisan blue ribbon groups to develop election reforms. We will then hear from Derek T. Muller, who is a faculty member at the University of Iowa Law School. Derek's research focuses on election law, particularly the role of states in the administration of federal elections. He graduated from the University of Notre Dame and worked as a judicial clerk for the Honorable Raymond W. Grinder of the United States Court of Appeals for the 8th Circuit in St. Louis, Missouri. He then practiced litigation with Kirkland and Ellis in Chicago. Professor Muller has taught at Penn State Law, Notre Dame Law School, and Pepperdine. He teaches election law, federal courts, civil procedure, admin law, and evidence. Next, we'll hear from Professor Richard Pildes. He is the Sudler Family Professor of Constitutional Law at NYU. Rick is one of the nation's leading scholars of constitutional law and a specialist in legal issues concerning democracy. A former law clerk to Justice Thurgood Marshall, he has been elected into the American Academy of Arts and Sciences and the American Law Institute. He has also received recognition as a Guggenheim Fellow and a Carnegie Scholar. In dozens of articles and his acclaimed casebook, The Law of Democracy, he has helped create an entirely new field of study in the law school. His work in this field systematically explores legal and policy issues concerning the structure of democratic elections and institutions, such as the role of money in politics, the design of election districts, the regulation of political parties, the structure of voting systems, the representation of minority interest in democratic institutions and similar institutions. Finally, last but not least, we'll hear from Dean Daniel Takagi. Dan is the Fred W. and V. Miller Dean and Professor of Law at the University of Wisconsin Law School. He serves in that capacity as the Chief Academic of the school, with responsibility, of course, for faculty and staff development, personnel oversight, strategic planning, and institutional vision, fundraising, budget planning, all of that great stuff. Before joining the University of Wisconsin, Dan served as an associate dean for faculty and the Charles W. Ebersold and Florence Whitcomb Ebersold Professor of Constitutional Law at the Moritz College of Law. Taught a wide variety of courses, including Civ Pro, civil rights lawyering, constitutional law, election law, and voting rights law.
Still on it.
Thank you all so much for joining us as the panelists for this very important bookend to this conference. I will turn it over now to Josh to kick us off.
Thanks, thanks, Dean Nelson, and it's great to see so many election law friends and others who I don't yet know, but I'm sure will become election law friends. So this panel is to put a cap on this wonderful two-day conference that I've learned so much from, and we're tasked with discussing improving presidential elections. And of course, part of improving presidential elections is ensuring that people have access to the ballot, is to protect the right to vote. And we, in many instances, rely on the courts to do so. And voters, as we all know, faced numerous challenges voting in the 2020 presidential election, given the pandemic and given the current state of democratic discussion. And some legislatures responded to ease voting rules, but others refused. And when they refused, we saw secretaries of state, governors, election boards, and even state Supreme Courts take the charge to protect the constitutional right to vote. So when asked, how should we improve presidential elections? I think we need to look at what is the US Supreme Court doing as an election nears with respect to the right to vote, and how can we or should we not rely on Supreme Court jurisprudence? So I'm going to talk during my time about an essay I wrote called Undue Deference to the States in the 2020 Election Litigation that looks at the pre-election day litigation. We saw a flurry, dozens and dozens of cases, actually hundreds if you include state courts as well. But I'm going to focus on the US Supreme Court and the Federal Courts of Appeals to see what did they say about the right to vote and about how to approach election litigation in a presidential election year, and what does that suggest for the future? And in my view, this is not very good news. Now, as a background, the right to vote, the Supreme Court has said, is located or recognized within the Equal Protection Clause of the 14th Amendment. And the main test the court uses is referred to as the Anderson-Burdick test, named after two cases, Anderson and Burdick. And when a plaintiff, a voting rights litigant trying to effectuate the constitutional right to vote, has some burdens, shows that a law imposes some burdens, if they're not, as long as they're not severe burdens, they still apply a test that is supposed to put the states to the task of justifying their laws. So if it's a non-severe burden, the state must show, quote, that the precise interests put forward by the state as the justifications for the burden imposed by its rule, and the extent to which those interests make it necessary to burden the plaintiff's rights. So even when we're under this kind of a lower intermediate style scrutiny where we're not applying the strict scrutiny test, we still are supposed to apply, the courts are still supposed to apply a intermediate balancing test where we weigh the burdens that a law does impose against the state's interest for the law. But what we saw in the 2020 election litigation is that the US Supreme Court and the federal appeals courts barely applied those two prongs of the test and simply deferred to the states. And I refer to this as undue deference. that the states were given almost unfettered discretion to regulate the upcoming election as they wanted. And in many cases, voters were left without the ability to effectuate their rights. And we see this in particular in the many cases where district courts ruled in favor of plaintiffs, said that the state's restrictive rules with respect to absentee balloting or witness signature requirements or drop boxes made it harder for voters, particularly in a pandemic, to cast a ballot that would count. And on the balance side of this test, when your state is supposed to justify its precise interests for the law and why it's necessary to burden the plaintiff's rights or the voters' rights, the district courts found that the states didn't have any valid justifications. But appellate courts and the US Supreme Court reversed those decisions. They credited the state's general non-specific justification of preventing election or promoting election integrity or preventing voter fraud, and essentially said that state legislatures have essentially plenary power to regulate elections. And so the protection of the right to vote turned into an undue deference standard, and one that places a thumb on the scale of state legislatures, especially as an election draws near. So instead of seeking the precise interests from the states and making them justify why the laws were necessary to burden voters' rights, the court simply deferred to the state legislatures. And so in this way, what we see from the 2020 pre-election day litigation is as if the federal courts almost silently overturned this Anderson-Burdick test and almost applied a rational basis style test in gutting these second and third prongs where the states are supposed to actually justify their rules. We saw this from Justice Gorsuch and Justice Kavanaugh in a case out of Wisconsin, where these justices wrote that the Constitution says that state legislatures only should be able to regulate the voting rules, and didn't seem to recognize the harms that voters would face during a pandemic. And so it seems that Anderson-Burdick is on life support, replaced by a standard that is simply deferential. I talked about the district court cases. There's at least 18 cases in 2020 where the district court ruled in favor of voting rights plaintiffs and invalidated a state law or practice, often due to the difficulties that voters would face during the pandemic, only to see the circuit courts of appeal reverse those decisions, or the US Supreme Court reverse those decisions based on deference. And so this is unfaithful to this Supreme Court precedent, but the court didn't actually explicitly overrule it. As one dissenting judge in the Eighth Circuit said, the state interest must be linked in some meaningful way to the particular rule or regulation that allegedly imposes a burden on a citizen's right to vote. But most judges, appellate judges, and the Supreme Court justices did not do so. And so what you get is you combine this with another doctrine that I think Michael's going to talk about, the independent state legislature doctrine, which says that state legislatures basically and nobody else should be able to promulgate election rules. Combine the undue deference standard with that independent state legislature doctrine, and then combine it also with the so-called Purcell principle, this idea that you can't change election rules too close to the election. And the result is that state legislatures have almost unfettered plenary power to make election rules with very little to no oversight. And so what does this mean for the constitutional right to vote and for presidential elections? Well, the right to vote is underprotected. And also, we're trusting state legislators, who are really the last people we should trust to create election rules, to do so because they're self-interested, right? They could craft rules to decide who can vote and thereby try to shape the electorate as they wish. So what we need to do is reimagine the constitutional right to vote so that courts don't give state legislatures so much deference in crafting the rules of the game. This could be through federal legislation, could be through a constitutional amendment, could be through the courts recognizing the problems that they have engendered by ignoring this, the state interest prong of the Anderson-Burdick test. And I'll close by noting that I'm a big baseball fan. And so I often think about how, if, let's say, the Yankees and the Red Sox, two big rivals, were playing each other. And yet the Yankees got to choose the umpires, as well as the commissioner of baseball that got to set the rules for how the game is played. No one would think that would be fair. But this is essentially what we have through this deference to the states, and that impacts the way in which we regulate and the way in which we administer the presidential election.
Thanks so much, Josh. I'm going to pass the virtual mic to Michael.
Great. Thank you very much, Dean Nelson, and I appreciate AALS for organizing this conference. It's a privilege to be able to participate. I'm going to talk today about a topic that both Professor Katz and Professor Douglas had alluded in their presentations, which is the independent state legislature doctrine. The doctrine arises from the wording of the Article 1 Elections Clause and the Article 2 Presidential Electors Clause, whereas many provisions in the Constitution talk about the states and give the states particular power or the states particular responsibilities. These two provisions pierce the veil of statehood, so to speak, and instead single out the legislature. They say the legislature of each state shall determine the time, place, and manner of congressional elections, and Congress can make or alter those rules. The legislature of each state will determine the manner in which presidential electors are appointed. And so the question arises, what, if any, constitutional significance arises from the fact that rather than conferring this authority on the states as an entity, the Constitution instead singles out the legislature as having authority to over these issues? And one important point that becomes clear once you start looking into the case law and the history of this is that the independent state legislature doctrine can actually have a range of potential implications with each of these different possible applications of the doctrine involves somewhat different strains of case law. And so it's entirely possible to accept some implications and reject others, to invigorate a common law professor phrase, you can think of the doctrine as a they rather than an it. One other important detail about the doctrine is that while we saw it being vigorously pushed in many cases by various plaintiffs, it's not something that was manufactured in the course of this election. In fact, if you look through the 1800s, the independent state legislature doctrine was applied by state Supreme Courts. It was applied by the chambers of Congress in resolving election contests. It was discussed in treatises dealing with constitutional law and election law. It was even invoked by Justice Story and Daniel Webster during the Massachusetts Constitutional Convention of 1820. So while the doctrine has largely fallen into desuetude in the 20th century, throughout the 19th century, it was a generally accepted approach to interpreting these constitutional provisions. One other important aspect of the doctrine is that it plays an important role in why we have the 19th Amendment today. There had been several states who had, with state constitutions, that prohibited the legislatures from doing anything to extend the right to vote to women. There were provisions in those state constitutions that were interpreted as purporting to bar those legislatures from ratifying a federal constitutional amendment that would expand the franchise to women. When the 19th Amendment was passed by Congress, it was sent to the states for ratification. Several of these states, despite the prohibition in their state constitutions, nevertheless went on to ratify the 19th Amendment. And when the case went up to the US Supreme Court, the US Supreme Court said that because the power to ratify constitutional amendments comes from the US Constitution, it was conferred specifically on the legislature of the state. State constitutions were incapable of putting substantive constraints on the scope of that power. And so therefore, those state ratifications, despite the fact that they violated their state constitutions, were nevertheless deemed valid, and the 19th Amendment was deemed to be a part of the US Constitution. So I spoke before about the notion that this doctrine, the fact that the US Constitution singles out the legislature, could have a range of possible implications. I want to briefly, in my time remaining, just walk through some of them. First, most basically, there's the notion that because the legislature is the only entity within a state that has authority under the federal constitution to regulate federal elections, that when other state actors take action with regard to a federal election, they simply need to be able to point to some sort of delegation of authority, some sort of authorization from the state legislature for the actions that they took. And so we see a handful of district court cases, many of them originating in Ohio, where the Secretary of State took particular actions, issued certain orders in connection with an election. There was no statutory authorization for those particular actions. And the federal court found that not only was this invalid under state law, it also amounted to a violation of the Constitution. Bush versus Palm Beach County Canvassing Board points to a second possible implication of the doctrine, the notion that because legislatures have authority to regulate federal elections, courts have to be careful to ensure that when they're interpreting, when they're applying election laws as they relate to federal elections, that they're paying special attention to what the legislature enacted, which would basically mean a special focus on statutory text, even if in the ordinary course of events, the courts would take a more atextual approach and would consider other sources, perhaps state constitutional provisions, their own substantive judicial doctrines in interpreting laws. And so a question arises as to whether the doctrine in any way constrains the ability of courts when interpreting state laws governing federal elections. Of course, one of the main conflicts, and we saw this arise several times in the course of the 2020 election, though never in circumstances that threatened to actually impact the outcome, is the question of whether state laws regulating federal elections can be struck down under state constitutions. Right? Under the doctrine, the argument would go that because the power to regulate federal elections comes from the US Constitution, state constitutions cannot impose substantive constraints on it. And so when legislatures act, they are subject to US constitutional constraints. They are subject to federal statutory constraints like the Voting Rights Act. They are subject to inherent limitations of provisions like the Elections Clause, but they're not subject to substantive restrictions in the state constitution. And that is perhaps one of the most important potential applications of the doctrine that the Supreme Court needs to directly address. There's a line in the Arizona independent redistricting case from 2015 that suggested the 5-justice majority in that case would have rejected it, but that this is something that particularly after the 2020 election, the court needs to address head on. I see my time has elapsed, so I'd be happy to talk about some other potential applications in the Q&A.
Thanks so much, Michael. Your comments, especially layered and intersecting with Joshua's, are particularly thought-provoking. With that, let me turn it over to Derek. Thanks so much, Mike.
Thank you, Dean Nelson, and thank you for all the participants here. It's been an enlightening conference so far. Again, many friends and familiar faces. It's great to be a part of this. So I want to focus on sort of a different aspect of the presidential election, thinking about Congress's role in counting electoral votes, which I spent a long time thinking about. Many of us on this panel a year ago were talking about this at a conference. It's something that often flies under the radar, but certainly not on January 6th, as there was the riot at the Capitol and the loss of life and all the events that flowed from that. But we can think about the act that Congress is going to have to do again in 4 years when it counts electoral votes. And that role is usually pretty ministerial in nature. But in the last several elections, Professor Brad Smith earlier sort of identified this too, we've seen an escalation occurring in Congress in terms of Congress's interest and willingness to object to counting electoral votes. And the contemporary rule that we use, contemporary from 1887, is the Electoral Count Act, which sets the framework for how Congress is supposed to go about counting electoral votes. And in particular, the objection that was filed on January 6th was an objection that Arizona and Pennsylvania had not given their votes that were under all the known circumstances regularly given. And this phrase regularly given consistently appears in objections filed or attempted to be filed by Democrats and Republicans in the last 20 years. It's sort of this rote language that comes out of the Electoral Count Act. And it's become kind of an omnibus, right? Essentially, it's used for almost any kind of objection somebody might have. I think this state didn't comply with the Voting Rights Act. I don't think this state's recount procedures were appropriate. I think this state's judges usurped the legislative role in creating election laws ahead of the election, whatever it might be. And so Congress has used this sort of simple language and yet put all of its sort of substantive concerns about how a state's electoral votes were compiled, tabulated, transmitted to Congress. So I have a paper coming out in the Georgia Law Review taking a look at this and really about this phrase regularly given. And the first thing I do is start looking at how that phrase, it's not a phrase we use very often today, how that phrase as a legal term of art was used in the late 19th century. And you can see this phrase used all over the place. Notice is regularly given. Taxes can be regularly given. A judgment is regularly given. Testimony is regularly given. And in each of these contexts, I think you can see it just simply means some act or some exchange that arises pursuant to law. That's all it means, right? So when we think about that there's something done or pursued pursuant to law, and that's despite sort of substantive concerns that might underlie whatever that sort of formal exchange is. So a judgment can be regularly given in the late 19th century, even if the judgment is an error, right? If we think the judgment is substantively erroneous. Or notice, right? Notice can be given to somebody, please produce this document. And that notice is regularly given, even if the notice is deficient in the sense that I lack possession of the document and can't give it to you, right? I'm unable to comply with the terms of it. So we can separate those things that are the procedural exchange pursuant to law, separate and apart from those substantive underlying concerns we might have with the thing itself. So in the context of the Electoral Count Act, it totally makes sense to think about it in terms of a separation between Congress's role in assuring that whatever comes out of the states is appropriate pursuant to the rules that Congress has set or that the states have set, as opposed to anything leading up to the election and selection of those presidential electors, right? We can see when electors meet in state capitals around the country in late December, they formalize their votes, they write them down and submit them to Congress. And we can sort of trace everything in that process from the electors meeting in the Capitol, complying with the 12th Amendment, complying with other rules, to sort of transmitting them up to Congress to take a look at. But all that other stuff that happens before that moment is really not something that we should be examining because it gets to sort of the substance of the election of the electors themselves. It gets to some substantive questions behind that selection process that are not about this question about whether or not the votes have been regularly given, because the votes are those things that the electors have done. So when we look at it in the recent series of objections that have been filed in Congress, essentially all of them failed this test, right? In 2001, the attempted objections are that Florida failed to follow the Voting Rights Act, that Florida miscounted its votes, and that Al Gore was the real winner. Those are not objections about the regularly given, about the electors who gathered in Tallahassee, cast votes, and sent them to Congress. In 2005, there were challenges to Ohio's electoral votes that they were not regularly given. They were unlawfully appointed, whatever it might be, long lines at the polling places, dubious voting machines. Again, all those kinds of things were inappropriate objections if we're only looking at the act of the electors gathering together and submitting their votes to Congress in terms of what is or isn't regularly given. 2017, there were myriad objections that were attempted to be raised. No senator joined them, so they were never formally considered by Congress. But some of them, considered the objection to Alabama was that it was illegal activities by the government of Russia and widespread violations of the Voting Rights Act. Again, things that get to the sort of the substantive validity of the election, not the things that we think are sort of procedural questions that arise once the electors have met. The exact same thing arose in 2021, saying we have all these questions about the elections, whether or not it was a kitchen sink of fraud, of absentee voting, of whatever it might be. And the thought is, if we can look at this instead, that Congress has narrowed its discretion, it doesn't have the opportunity or tools to go dig in and figure out what happened. That's what the courts are for. That's what the sort of canvassing process is for, and a recount process and an audit process. And all those things are left squarely to the states. When it comes to Congress's role in counting votes, however, this phrase regularly given in the statute constrains Congress and really ought to do so. And there's a lot more to talk about. I'll just tick off, I think, the 5 things that Congress can consider as I wind down here. The first is that if an elector has cast a vote for an ineligible candidate, someone who cannot be elected to that office, if a candidate has died, for instance, as it did in 1872. The second would be if the elector cast the vote at the wrong time or in the wrong place. This famously came out of Wisconsin in 1856, where a blizzard prevented the electors from meeting on the appropriate day. Congress ultimately counted the votes, but that would be the kind of objection we're talking about. Third, that the elector cast the vote in the wrong manner. In 1872, there's a challenge to Mississippi's election saying they didn't specify that they voted by ballot, right? They counted the votes, but that would be the kind of objection. The fourth is that Congress, that the electors didn't report their votes according to law, a list, sign, and so on. And finally, if the vote was the product of duress, bribery, corruption, or some other improper influence. And maybe these feel like anachronistic concerns, and maybe we can cure them in other ways, but I think it suggests there's a very limited, circumscribed role for Congress when it comes to refusing to count electoral votes. Thank you.
Thanks so much, Derek. Appreciate it. Let me hand it over to Rick now.
Thanks, Dean Nelson, particularly for performing the thankless role of moderator. I always find it to be the toughest role on these panels. And thanks to the AALS and to Erwin Chemerinsky in particular for inviting me to participate. I want to speak broadly at first to put my comments about the presidential election process in context. I consider that the most serious challenges American democracy faces today arise from the forces of polarization and extremism that are roiling our political era. The dangers to democracy from the kind of extremism that unjustifiably denies the legitimacy of democratic elections are obvious, but hyperpolarization of the political parties, as I've called it, also poses another kind of danger. Because in our system of bicameralism, separated powers, it typically takes some degree of bipartisan support to enact major legislation. As the congressional scholar Francis Lee has shown. President Biden, to be sure, managed to enact his first major piece of legislation through reconciliation with only Democratic support, but it remains to be seen how much of the rest of his agenda can be adopted if he fails to garner any bipartisan support. And more broadly, one of the greatest dangers Democratic governments across the West face today is their seeming inability to deliver effective government on the issues, economic and cultural, that voters care most about. That's why across democracies, we're seeing the dramatic destabilization and reconfiguration of the coalitions that support the parties of the right and the left, the sudden upsurge of third, fourth, yet more parties, the much longer time it takes governments in PR countries to form governing coalitions, and a lot of other manifestations of this disaffection from the traditional political parties and processes. And if democratic governments can't deliver effective government on the issues voters care most about, it can lead to distrust, alienation, withdrawal from participation, or even worse, the desire for more authoritarian leaders who promise to cut through all of this dysfunction. So for these reasons, I consider political reforms that can help mitigate extremism and polarization to be among the most urgent tasks of American political reform thought and advocacy. I wanted to try to flag 3 primary areas first, and then focus primarily on the presidential nomination and election process. So first, we need to change the structure of primary elections. I know Ned Foley spoke about this at an earlier panel. Given how low turnout is, primaries today often eliminate candidates who would actually have the broadest appeal to the larger general electorate. We're all aware of how much the fear of being primaried shapes politics today. Leading incumbents in safe seats to move to the extremes to preempt this threat, or leading moderate senators to retire because they know they can't survive their party's next primary. So without going through all of the different ways we can think about political reform of the primary election structure, one thing I would mention is eliminating sore loser laws, which prevent candidates who lose a primary from competing in the general election. If Alaska had such a law, Lisa Murkowski wouldn't be in the Senate today, despite her wide support in the state. There's been a lot of talk of moving to things like the top 4 primary structure combined with use of ranked choice voting in the general election. But reforming the structure of primaries has to be a major item on the agenda given these larger risks, in my view. Second, as we enter a new round of redistricting with independent commissions drawing more districts than ever before, we should give more weight, in my view, in this process to creating competitive election districts, consistent with all the legal requirements to govern redistricting, such as the VRA, equal population, and the like. Competitive districts force candidates to the center, safe seats push them to the extremes. I know some political scientists disagree with this view, but I've explained elsewhere and recently why I think they're wrong in a Real Clear Politics essay I published recently. Currently, only about 17% of seats are competitive in the House, and redistricting that emphasizes competitiveness could certainly generate considerably more than that. And if you imagine just even doubling the number of competitive seats in the House, even if it's only a third of the House at that point, that would make, in my view, an enormous difference. Third, we should be careful about racing to nationalize small donor matching programs for campaign financing, in my view. I understand and share the values of participation and equality that motivate these proposals. But all of the data we have indicates that the candidates who benefit most from small donors come from the ideological poles of the parties. We don't want to throw accelerants onto these fires, in my view, and we should consider other forms of public financing, which I support, including ones that would direct more funding to the political parties to distribute to the candidates of their party as they see fit in their effort to maximize their overall prospects in elections. Okay, with that said, to turn now finally to presidential elections, I also think as a fourth area of reform to mitigate extremism and polarization, particularly extremism, we need to reform the presidential nominations process. The most profound change we have made in the last 50 years to our political process was the shift in the 1970s from the party nominating conventions to the most populous system any major democracy uses for choosing its party nominees, the system of primary elections with a few caucuses that are familiar to us. Most Americans take that system that we have for granted. I think many people think this is simply the only way or the most natural way a democratic system would choose its nominees for the highest office in the land. But for 170 years, the party figures from throughout the country, national, state, and local, along with voters, had significant say in who their parties nominated. It's because of this shift to primary elections that we end up with situations in which there are 21 people competing for the nominations. And with such crowded fields, celebrity status, name recognition matter enormously. In the prior system, potential candidates had a broad set of interests within the party, represented by these party elected officials from all levels of government. With today's primaries and crowded field, however, it's now possible for a factional candidate to win primaries with 35% of the vote and capture the nomination. So one modest reform here would be for the parties to use ranked choice voting in their primaries. This is actually a way, I think, of recapturing some of the need to appeal to diverse interests within the party from the old convention system, but applied to an era in which voters completely control the choice. And the political parties used RCV in 2020, the Democrats in 6 states, the Republicans in 1. It would make it harder for factional candidates and extremists to be nominated, since they'd have to reflect a broader consensus within the party to win under ranked choice voting. There are more significant changes to the nominations process we can talk about that they're unlikely in the current political culture, but just to give you some sense of how other major democracies do this, in many systems, the party figures in parliament winnow down the candidates to 2 or more, depending on the country, who then are presented to party members for a vote. In other countries, the law requires the parties to pick their leaders at a national party conference, which might sound very broad-based, but typically means several hundred or 1,000 party figures. I understand that those kinds of changes would be certainly more difficult in our modern political culture, but I think changing the nominations process and improving what we currently have is certainly something I suspect many Americans think would be a good thing to do. So political reform, in my view, should keep the concerns about polarization and extremism front and center among all the different avenues of political reform we're talking about. And as we debate ways of improving the presidential election process with the democratic election process more generally, I think these focal points, polarization and extremism, really have to remain absolutely at the center of our thought. Thanks.
Thanks very much, Rick. I appreciate your comments. In particular, thank you for illuminating the context within which deliberations about improving presidential elections takes place. I think it's important to understand and appreciate where we are at this moment. And I want to remind everybody in terms of our panelists, after Dan speaks, I'm going to open it up for you to engage with each other as the experts that you are, and then I'll look to the chat for questions that are coming from the attendees. So with that, Dan, last but not least, nice to see you. Turning it over to you.
Wonderful to see you, Dean Nelson. Thank you so much for moderating this panel. I am delighted and honored to be with such a distinguished group, including not only my co-panelists here, but the others who presented as a part of this great conference. I want to pick up where Rick and you, Camille, just left off by highlighting the backdrop against which presidential elections are taking place. That is this background of hyperpolarization and extremism, most notably evident, I think, on the right, but also evident on the left to some extent, which makes our democracy, in my view, much more vulnerable than it has been at any point in our lifetimes. January 6th and the events of that day are just the most visible example of that. And to be sure, the problems in our democracy run much deeper than presidential elections and the way that electoral votes are counted, for example. But if I had to pick the point in our process where if we are going to see a breakdown in our system that could lead to something much more closely approaching authoritarianism, it would be at that point. It would be at the point of a contested presidential election. Witness the fact that the election we've just gone through was not all that close. I mean, certainly compared to recent elections in 2000 and 2004, by way of example. And yet, there was a substantial portion of the population that refused to accept, and to this day still refuses to accept, the legitimacy of that result. So with that as a backdrop, I want to focus on a particular problem having to do with the timing of presidential elections and make 3 points in this regard. The first has to do with the so-called safe harbor date and the date for electors meeting in the states to vote that is set by the Electoral Count Act that a couple of the panelists have already referred to. In a piece that I wrote way back in 2008, I urged that the dates for the safe harbor and the counting of electoral votes be moved back, that they both be moved back by about 2 weeks. For the past election, the safe harbor date, and that is the date by which states have to complete their post-election processes, including litigation, in order to be sure that the certificates will be recognized in accordance with that vote when Congress meets to count the electoral votes. The safe harbor date in this past election was December 8th. The date that electors met in the states was December 14th. The problem here is that that first date is 5 weeks and the second date roughly 6 weeks after the election. There is no guarantee that post-election litigation will be wrapped up by then. And again, this past election wasn't all that close, and yet we still had cases going on right up until, and in some cases after that date. Imagine what things would be like in a close election. the second point I want to make is that although I still think it's probably a good idea to move back those dates, I have been given some pause by the events in this most recent election. As you all may recall, we had a delayed transition, right? The then current administration did not recognize the result and thus delayed the funding of the transition to the Biden administration. The risk, if you were to move back those dates, is that the transition is therefore going to be delayed. And so I do recognize that the costs of moving back the safe harbor date and the date for electors meeting in the states to make room for post-election litigation are greater than I thought back in 2008. I still on balance think it's probably worth doing, but I have to say these events have given me some pause. Altogether, however, I think it's probably better to have more time to resolve post-election disputes, even if it means that the transition to the new president may be delayed a couple of weeks or the beginning of the transition process. The third and final point I want to make concerns the interaction between this relatively short period for resolving post-election disputes in presidential elections and a doctrine that the Supreme Court has developed over the past 15 years, often called the Purcell Doctrine. It arose from a case out of Arizona, Purcell versus Gonzalez. This was a challenge to an Arizona voter ID law in which the Ninth Circuit had issued an injunction that the Supreme Court reversed, noting in its very brief order that injunctions by federal courts issued very close to an election can be disruptive. This point by itself strikes me as altogether unremarkable. I don't necessarily agree with what the court did in that case. I don't think, however, that decision, that order taken by itself is really all that terrible. What's happened in the intervening years, however, is that this presumption against federal court injunctions issued close to an election has hardened into something close to an absolute rule. We saw the most striking evidence of this development, and to me, disturbing evidence, in a quartet of cases decided in 2014 out of Ohio, North Carolina, Texas, and Wisconsin. And we've seen this development also in the 2020 election, where Josh alluded, I think, to it earlier, when federal courts issue injunctions, often challenging a problem that has very recently come to light, often federal appellate courts or the Supreme Court will reverse them, citing this case, Purcell. Why is this so problematic in presidential elections? Well, the reason it's problematic in presidential elections and generally is because it makes it much more difficult to bring a pre-election challenge to a new election law or a new election problem, right? At least to bring that challenge in a federal court, which is often where plaintiffs want to be, especially when they're raising claims under federal law, such as the Voting Rights Act or the Equal Protection Clause. It makes it very difficult for you to get relief from a federal court for a problem that is newly emergent before the election. And before every election, there are inevitably a bunch of new problems that emerge. For example, last-minute orders from secretaries of state and the like. The consequence of Purcell, because it's made it more difficult to get an injunction before the election, is to channel those disputes towards post-election litigation. And that is a really, really bad thing, especially when you consider the short timeline, because what we could see is that in a genuinely closely contested election, like the one we had back in 2000, there simply isn't enough time to resolve all of the issues and work them through the appellate process in an adequate way. And what we might wind up seeing is the state legislature or a state's governor or Congress getting into an act and taking matters into their own hands. So what could be done about this? Well, I do think that this is something, and I'll conclude with this point, that Congress could address. Right? That this presumption is not something that is constitutionally required, that is the strong now presumption against federal courts issuing injunctions close to an election. It is something Congress could reverse. Congress has the power to regulate federal judicial procedure in general. And I think that Congress can and should do so. It might be that the Supreme Court would invent some constitutional doctrine to make that more difficult or impossible, but I think that would be a very salutary change, which would not only reduce the severity of this problem for presidential elections, but for all elections.
Thank you very much, Dan. Appreciate your comments. I want to allow for some time for each of you to ask questions or engage with each other before I look to the chat with questions from our attendees or pose some questions that I have percolating myself. Any comments, insights, questions for each other, panelists?
I'll bite.
Okay, and then I see Rick was also, you're just muted, Rick, so.
Okay, well, I'll bite because I think perhaps the biggest point of disagreement was probably between me and Michael with respect to the independent state legislature doctrine and its efficacy or lack thereof. I'm very concerned by both the use of this doctrine and what I identified as the undue deference standard, where we just defer to what state legislatures say, so they're both not constrained by state constitutions and they're not constrained by essentially the US Constitution as interpreted by the US Supreme Court, which lets state legislatures have unfettered authority. And again, I think this is concerning because it leads to the potential of entrenchment. And you might say that, well, judges are no better at regulating election rules and being less than partisan, but at least the judges are not necessarily crafting the rules the very rules under which they're going to run for re-election. And so I thought I'd highlight, I don't know if Michael plans to respond, but I wanted to highlight that there's a little bit of a disagreement here in terms of that doctrine, because I find it a lot more concerning than I think he does.
Yeah, and I'm going to ask Bo, LSAC events, and again, thank you, LSAC, also for your sponsorship and support of this event. It's tremendous. Michael, do you want to respond? And if hopefully you can be unmuted, and then I'll turn it to Rick.
Sure, great. So really, the main point of my talk, number one, was simply as a descriptive matter to explain the various potential applications of the doctrine and the fact that it has become an issue that the court needs to address. So I don't know that I was necessarily taking a normative view of the doctrine or going so far as to defend it, rather pointing out that certainly it has a historical basis, it has a textual and a structural basis. I certainly take your point that there are also reasons for concern about it. The one thing I'll say is, because it is limited only to federal elections, right? It arises from the US Constitution about the regulation of congressional and presidential elections. You don't necessarily have that concern about self-dealing, because the doctrine doesn't empower state legislatures to set the rules for their own elections, right? It empowers state legislatures subject to federal law, subject to the US Constitution constraints, it gives them some degree of authority, right, just over federal elections. And I'll point out, right, the Elections Clause does the same thing with Congress, right? I mean, the Constitution expressly authorizes self-dealing in that sense by saying Congress not only gets to set the rules for congressional elections, but gets to determine the outcomes of congressional elections. So to a certain extent, that type of political theory, viewing elections as primarily within the control of political branches, is somewhat baked into the Constitution.
Thank you, Michael, and thank you for that insight as well, Joshua, and for your response, Michael. Rick, do you want to jump in?
Yes, so I guess I'll direct this to Derek, although anybody else who wants to chip in on this would be great. Derek talked about the Electoral Count Act, and this is obviously a key statute for regulating the presidential election process. And I'm been working with a group that's trying to put together a draft of a proposed redraft of that statute for Congress. And one of the questions, Derek, is this difficult choice about whether a reform statute should empower one specific official in the state, maybe the governor, to have the authority to certify the electors after the state has made its final determination through its ordinary processes, in which case we would almost never be in a situation of two potential slates of electors going to Congress. Or should a reform statute still contemplate the possibility of multiple slates going to Congress? And the policy choice here, the reason it's hard is that if you allow more than one slate potentially to go to Congress, then you're throwing the process into the highly partisan context of Congress. If Congress specifies only one state actor has the legal authority to certify, then you're putting a lot of power at the state level in that official, although I suppose state or federal courts could overturn a certification if it was illegal. But anyway, I'm curious, Derek, this goes somewhat to the question of regularly given that you were focused on, and how reform of the statute ought to think about that tough choice.
No, I agree. It's a great question. In 1887, the thought was, let's lodge that authority in the executive. That's sort of, and really the tiebreaker. Congress could always, if both houses of Congress agreed, ignore that decision that was made by the governor and go in a different direction. And there's a piece of me that looks at the history. We've had one situation where multiple slates of electors have been submitted. That was Hawaii in 1960. And the governor signed off on the Republican slate. And then later, after court order, the governor signs off on the Democratic slate. So there is a sense in which governors have behaved really well. And I guess the fear is, well, if you give them more of this sort of final authority and you really sort of ratchet it up and say, Congress is no longer going to consider multiple slates, whatever the governor says goes, does that put new pressure on the governors? Governors had extraordinary pressure. I think in Georgia and Arizona in particular, there was extraordinary political pressure among Republicans to pressure those governors to do something creative or different. And they didn't bow to that pressure, despite the fact what lots of legislators were doing. So there's a piece of me that thinks for a long time we've trusted the executive. I think there are opportunities for courts to review that. If the governor is acting ultra vires, if they're signing off on a slate that was not certified by as the statewide majority winner on the existing canvassing processes, right? I feel like there's some opportunities to think about, the governor not just making it up, right? The governor is really sort of just ratifying what the rest of the process has done. And so for that reason, I trust it more, but I totally understand the concerns on the flip side and recognize the danger inherent in any of these systems.
Thank you, Rick, and thank you, Derek. Mike, you have a question, and then I'm good. And Dan, I think you're signaling you have a question as well. So I'll go Mike, Dan, and any responses. Then there's a question in the chat that I'm going to ask you to please look at in the meantime. Mike.
Great, thank you very much. I had a question for Professor Muller. I'm really looking forward to reading your piece on this. It sounds like a really important and interesting piece of especially the historical research. My question was, is the ultimate conclusion that these types of objections are of the sort that you had identified are just categorically inappropriate, or instead is the concern that they were presented in the wrong form, that they said that we're objecting that these votes were not regularly given, but what they should have been saying was we are objecting that these electors were not lawfully certified, right? Which is the other main buzzword in 3 U.S.C. 15, the statute that you're talking about there. So I wonder if you could just talk a little bit about that lawful certification requirement.
Yeah, it's a great point. I think one of the important things that helps, and I get at this in a separate part of the piece, is to think about lawful certification and regularly given as doing two different things, and help us to think about what we sometimes refer to in our trade as the denominator problem, right? And so if Congress wants to challenge the certification of the vote total, that these electors never should have been seated in the first place because of some problem, that's great and all. If it wants to sort of pick that bucket, and then maybe there's some other things that the statute has some difficulty thinking about whether or not there's an opportunity to file those kinds of objections and whatnot, but let's set that aside for a moment. If Congress wants to do that, it needs to be honest about what it's doing and not hide those concerns that it has concerns about the underlying election inside of the objection that these just votes weren't regularly given. And the point being, if you challenge the votes as not regularly given, the notion is then that the electors were still appointed. You have to get 270 electoral votes to get to a majority. And really, it doesn't change as quickly as throwing out the slate of electors in the first place. If you throw out the whole slate of electors, it becomes twice as easy to overcome the election, roughly speaking, as a matter of mathematics. And so by sort of shoehorning those appointment questions into the vote casting bucket, Congress is actually kind of empowering itself to make it easier to throw out an election than if they were more honest in the first place. So I don't get into sort of the true merits of the heart of your question, which is, should Congress be doing that in the first place? My sense is probably not. But if they're going to do it, they need to put it in a separate category and be clear and explicit about what they're doing so that we can recognize the true consequences of that and get at the real heart of the concerns there.
Thank you, Mike. Thank you, Derek. Dan.
Thanks, Camille. Just a couple quick points. The first is that I really want to emphasize the importance of the project that Rick and others are engaged in of taking a close look at the Electoral Count Act, including the timetable issue that I mentioned, but there are lots of other problems with that law, and it would be great to have some resolution and rewriting of it well in advance of the next election. My favorite quote on this is one by my former colleague, Ned Foley at Ohio State, who's on with us. In a Washington Post op-ed from December, he wrote, "I have spent much of my academic career trying to parse its meaning, that is the meaning of the Electoral Count Act, and I still find it impenetrable or at the very least indeterminate." And I think that's being very generous, and I'm even more confused in many places when I read this impenetrable act. The second point I want to make goes back to the exchange that Michael and Josh had on the independent state legislature doctrine. I have to say, I'm with Josh on this one. I do worry that readers or listeners who are not intimately immersed in the details of federal election law may not completely have followed this conversation. So just in a nutshell, Article 2, Section 1 of the Constitution says that each state shall appoint in such manner as the legislature thereof may direct electors, giving the power, it says, to the legislature. Article 1, Section 4 says the time, place, and manner of holding congressional elections shall be prescribed in each state by the legislature thereof. It's important to note that several years ago, the Supreme Court weighed in on the meaning of at least the latter provision, saying that the legislature really means the legislative power, and on that basis upheld a provision of state law that had been adopted not by the state legislature per se, but through its lawmaking process, specifically through its initiative of process to adopt a reform that embraced an independent redistricting commission in that state. Now, the problem, I get the formalist argument for saying the legislature means legislature. The functional problem is that it would create a catastrophic mess in our federal elections because our state election laws are a combination of laws made by the state legislature, rules promulgated by the executive branch, such as the Secretary of State, and state courts' decisional law, which interprets not only these, but also state constitutions, which were not adopted by the state legislature. And that is the really big problem. I get the point that Michael makes about delegation. I think that is indeed solvable. But if you were to take state constitutional law out of the rules governing federal elections, you have created a huge mess where all states' elections are now going to be governed by two sets of rules, one of which involves all three sets of those laws, that is the rules governing state elections, but the other of which has state constitutional law and state judicial decisions interpreting them taken out, and that would be catastrophic, which I think is a big part of the reason why the court several years ago gave the legislature a functional rather than a formalistic interpretation.
Thank you, Dan. And I know, Michael, you'd like to respond.
Just a few quick points in response to that. I mean, whether or not there's separate regimes governing federal elections versus state and local elections would be up to the legislature, right? Most federal laws, other than the Voting Rights Act that govern elections, only apply to federal elections. And so, right, the HAVA, the NVRA, state legislatures choose to follow them for policy reasons, right? Prudential reasons for state and local elections as well. And in terms of just the practical aspect, right? I mean, there are certainly many ways the Supreme Court could deal with that. It could say it's not going to apply it retroactively. It could say that state constitutional provisions would be that already in existence would be presumptively applicable unless the legislature, wanted to override them. And most provisions of state constitutions governing elections are reiterated in state statutes anyway. Right? Certainly, that's the case in Florida. So as a prudential matter, I don't actually know that, again, depending on how broadly or narrowly the court embraced it, that it would necessarily lead to that sort of chaos.
Thank you. And thanks, Dan, for your question. And thanks, Mike, for your response. In the remaining time, I do want to get to some of the questions. There is a question from Ned Foley in the chat. And as strange as it may sound, 2024 will be upon us sooner than we think. So hopefully you've had a chance to look at Ned's question. I open it up to any of you who want to chime in about the likelihood of a three-way split in 2024 and his questions about the Electoral College winner.
I'll just jump in briefly on in terms of third parties. I know there's always a risk, like thinking about a true split of what a third party candidate is going to look like. And yet, like, serious third party candidates are like lightning in a bottle. It's Ross Perot and Teddy Roosevelt, and like that's it. And that's not to say there aren't others that have sort of, gummed up the works in the last 120 years. But I don't see sort of, whether it's a wing of the Republican Party or something like that, sort of branching off to create a third party in terms of creating that kind of a conflict. The legitimacy point, though, is an interesting one. Bill Clinton gets 43% of the vote in 1992. And while there's sort of, I think a lot of angry Republicans who sort of point to that as sort of an illegitimate outcome, you don't see the same kind of cry. And maybe 1992 is ancient history, right? We can't even compare what 2024 looks like if somebody were to get 43% of the vote on a popular basis and eke out an electoral college victory. I don't know, but I do agree it is a rising challenge. It's a reason why Rick's, I think, important work thinking about what we're doing in the primary system, or thinking about ranked choice voting or other things to sort of coalesce around majoritarian winners without having sort of as much factionalism in some of these processes is a really important project.
Yeah,
Rick, do you want to jump in?
Yeah, sure. Thanks, Dean Nelson. Yeah, I would say, first of all, it is true right now that the fragmentation or split inside the Republican Party is more extreme than inside the Democratic Party. Now, that's partly because there's a Democratic president, so that creates a certain amount of unity within the party supporting him. But the comment that Ned makes, or the prospect he raises, is a good reason why Republicans might be interested in ranked choice voting for general elections when it comes to something like this scenario where you have two really intense factions. I don't know if they're two equally intense by any means, but two factions in the party. The other thing I would say is normally one reason third parties don't keep going through the process is because they're worried, or their supporters are worried they're going to throw the vote to the wrong candidate. That these are all Republicans, let's say, but if they split the vote, a Democrat will get elected. I don't know how much that dynamic would hold here. I think that if you imagine a coalition, third party led by the sort of Liz Cheney, whatever we call them now, conservatives, and sort of Trump wing of the party, I don't know that a Cheney wing would not be happier having a Democrat reelected in 2024 than having the Trump wing of the party gain power. So I don't know that they would back down, even if it was clear they were only winning 25 or 30% of the vote and might split the Republican Party and throw the election to the Democrats. I don't know that the Trump wing would back down. facing that scenario, given how intense these tensions are within the party. So, there's a lot of bridges to cross between now and 2024. There is going to be an internal struggle within the Republican Party. How that struggle comes out after 2022 is certainly going to shape the reality of whether this prospect, is going to continue into the 2024 election, or whether the split will be settled and one side will be so dominant there isn't a major dissenting faction.
Thank you. Let me ask, given what you've all articulated around the epicenter of the evolution of presidential elections being located to a large extent with the states, are there certain states that within this discourse will emerge as more prominent than perhaps they have been historically? And then what does that mean for the prospect of reform, if that's the case? If it's not, why not? But love to hear your thoughts on that.
Well, I think about the primary system. I'm here in Iowa, and I hope this system doesn't change anymore, because I'm now contractually obligated to support the Iowa caucuses. I think it's, just thinking about Rick's point, I think about it again on the primary caucusing side. It's a really interesting time. Joe Biden placed 5th in the Iowa caucuses and comes out as the nominee, right? In some respects, the party coalesced around him, and a lot of other candidates who were maybe garnering some support sort of dropped out. So there was sort of a place for, as Rick was pointing out, whatever the calendar indicates, or whether it's primaries or caucuses, or whether it's, ranked choice voting or winner take all or whatever, there's still ways that sort of the establishment party, the sort of institutional party, can still sort of exert its will in appropriate ways, persuade people to drop out, whatever it might be. I don't know how much that works going forward. My bet is we're not going to see dramatic reforms in terms of the state-by-state approaches to the primaries. At least, maybe people think about dramatic changes about state-by-state approaches in the 2024 election. And if that's the case, it's really going to be incumbent on the will of the leadership of the parties. And again, I think because they're the out-of-power party right now, the Republican Party, to think about what that looks like in terms of exerting all of those extra legal sorts of influences upon the nominating process.
Thank you.
Yeah,
Rick, go ahead.
I disagree with that if there's time. Can I make a quick comment about that? I think the parties have lost a lot more control over the nomination process than the way Derek tells the story. If you look at, first of all, let's say the Obama-Clinton primaries. Clinton was certainly the candidate of the party establishment until Obama started doing well enough that the party began to move toward him. But if you say if the party decided through its leadership who the nominee was going to be, that I don't think that would characterize that. And I don't think John McCain would have been the choice of the Republican establishment. He was the maverick, after all. Obviously, Donald Trump doesn't fit that bill. He wasn't chosen by the party in advance of the primaries. And the fact that Bernie Sanders in 2016 came so close, he came close enough to knocking off, the establishment figure of the Democratic Party. And he was an independent. He had no support within the political party structure. So I think things have actually changed a lot. And I think the parties sometimes can coalesce around a candidate that they want, but I think we have lots of contrary examples now in the modern era.
Thank you. Are any other comments, Joshua?
Yeah, so in thinking about your question in terms of are there going to be particular states that are going to make a difference for 2024, I just wanted to highlight the fact that we're even having this conversation in May of 2021, 4 months into a new administration. When I became a law professor and I told my dad that I was going to focus on election law, he said, "Oh, so you're gonna, your work's gonna be relevant once every 4 years." Not realizing that election law is a never-ending endeavor, and we thought we could take a break after the 2020 election, and yet the work is not ended at all. And we've got the crazy Arizona audit going on right now. You've got laws being passed in Georgia and Texas and Florida and Iowa and other places. And so this is something that all of us on the panel think about all the time, but it's really entered the public consciousness as an everyday thing. And that's, I think, really changed over the past several years, and something that we need to be attuned to, is that this is a conversation that there's no such thing as an off year in election law anymore.
Yeah, well said, well said. Michael, I know you want to chime in.
Just looping back to Professor Pilditz's point on the role of political parties and their diminishing strength in helping to combat extremism, one of my absolute favorite cases to teach on this issue comes from his casebook, which is Duke v. Massey, which I think squarely presents the question of whether party leadership has the right to say to somebody who wants to appear on their primary ballot, like, no, you're not the kind of person we want representing our party, right? That case was, can the Republican Party keep David Duke off their ballot, say you don't reflect Republican values, and the 11th Circuit upheld that. So, and I think that law, that issue squarely presents this question of, do we want party elites to be able to have more control over who's representing that party? Is that in some sense, right, anti-democratic, not letting the right rank and file party members have who they want? And I think that case just perfectly encapsulates the issues that we're talking about here, and presents one of the types of legislative solutions in terms of empowering party leadership that would lead to some of Professor Pilditz's goals.
Thank you, Mike. Dan, last word, and then I'm going to have to wrap up in light of the time.
Great, thanks, Camille. I'll try to be quick. Well, let me take the opportunity on behalf of everyone to thank you and AALS for putting this on, and thanks also to Dean Chemerinsky, who invited me. The last point I want to make is just to note that in terms of what's happening in the states, remembering that most election law is state law, I think we're going to see an acceleration of the trend of blue states liberalizing their laws and red states constricting them. It's important to bear in mind that this may not play out exactly the way that everyone thinks. As the Republican Party's base has increasingly turned towards voters with lower education levels, that is non-college educated, mostly, predominantly, overwhelmingly white voters, it's not so clear that these more restrictive laws adopted by red states are actually going to help the Republican Party at the end of the day. But the big states to watch, I think, are ones that still have Republican legislatures but are trending blue, states like Georgia being the prime example. It'll be really interesting to see how these changes in state laws ultimately affect election results, including presidential elections.
Thank you, Dan. And thank you all so much. I so appreciate all of your comments. And I know I speak on behalf of the conveners and the attendees in saying this has been a really rich and informative conversation with much food for thought. I hope there is cause for hope, if not optimism, given the incredible work that you're all doing on the vanguard. But I want to celebrate you and appreciate your work in leading us forward through what might appropriately be seen as a quagmire of sorts in many domains. So thank you all. It is my great honor as well now to turn the virtual mic over to Dean Vince Rougeau, who will close out this wonderful conference.
Thank you so much, Camille. And I just want to echo everything you just said about the last panel. It was just fascinating. And I want to thank all the presenters for leading us through such an interesting set of issues. And thank you, Camille, for moderating. And actually, I want to thank everyone who presented today and yesterday for the just fascinating conversations, the challenging discussions that you've presented to us. I've been swinging back and forth all day between hope and despair, but I think I'm going to end on hope. I think there's so many great people working on these issues that want to move us forward, and I know that they will. As president of the AALS, I want to thank our co-hosts, the LSAC and Kelly Testi, the ABA, Patricia Rifo, and all the staff at the AALS and LSAC who organized this event so terrifically. We really appreciate all the work and support that you've given us. Again, thank you to all the speakers and moderators on both days, particularly Bob Bauer and Jack Goldsmith, whose book inspired this conference, and Representative John Sarbanes for his leadership on HR 1 and for the People Act, who opened the conference to open the conference today. Also, a special thank you to all of you who watched some or all of the conference. We're really glad that you took the time to be with us. The AALS will be posting a recording of the panels on our website in the next week or so. So encourage your friends, colleagues, students to take a look at these wonderful panels and learn from them. I hope this conference will inspire more scholars and more students to write on these important issues. And with that, I wish you all a wonderful afternoon and a great weekend. Good evening.